Yeah.
Make the announcement. Good morning, all the United members. One information. The dispensary gone clinic in the headquarters complex. Formally inaugurated today by DQ, the Commissioner Secretary Health and Family Welfare at 1 p.m. So I would request all the members to attend the inauguration. Even if your matters are over, please wait for some time and then attend to the formal inauguration. It will take it will take about 5 minutes only. Just to formally inaugurate and play about it.
My please, Lordship.
Yes.
I may be allowed to mention hearing item 36 to 38.
Okay. Yes.
I may be given 4 weeks time, my Lord. As the main counsel is in this post.
Lord Council.
The peace reign on behalf of peace reign.
Okay. So you are for respondent.
Yes, Lord.
Mr.
In all the petition.
Okay. You are Mr.
Pakinito, my lord.
appearing on behalf of
Kito TC.
Land Council for the petitioner. Praise for listing this matter after 4 weeks. As the main counsel for the petitioner is out of station. The prayers were made by the land council appearing on behalf of the petitioner. It's not been objected to by Mr. Land council for the respondent staff. The prayer is allowed. List is made after 4 weeks. Okay.
My lordship,
Yes.
on behalf of Livica, state respondent, was seeking for 3 weeks of time. 16, 17.
Okay.
And 21, 22, 23. Behalf of Livica.
21.
Yes, Lord. 21, 22, 23. 16, 17.
In all the matters he is appearing.
Yes, Lord.
Who is for the petitioner here?
Yes, Lordship.
Okay.
22, 23.
16, 17. You are
21, 22, 23.
In 16 and 17.
okay. Mr.
Ajungli.
appearing on behalf of Libica. Libica is land state council.
Yes,
Okay.
Lord.
When do you want
After 3 weeks, Lordship.
praise for listing this matter after 3 weeks? To which
3 weeks.
Hmm?
3 weeks.
3 weeks,
Lordship.
to which the land council for petitioner has no objection. The prayer is allowed. List is matter after 3 weeks. Okay.
No.
So in 21, 22, 23 also. So name will be changed.
May I please, your Lordship?
Yes.
I beg to mention item number 41. On behalf of my senior, Mr. Inpi Longjung.
Okay.
Your Lordship, my senior is indisposed today.
Hmm.
So kindly list the matter after 4 weeks.
Miss. You are for the, you are for respondent.
Yes, your Lordship.
Now, who is for the petitioner?
41.
Yes,
I am for the petitioner. Yes. After 4 weeks, Your Lordship.
out of 4 weeks.
Yes, Your Lordship. I will not be here for February.
Okay. Mr.
I am for the petitioner, few
Okay.
people.
Mr. B. Paul, land council for the petitioner is present. Stop. Miss
And solo,
appearing on behalf of,
the respondent.
Miss submits that. Senior Mr.
Inpi Longjung.
is indisposed and prays for listing this, prays for adjournment, stop, as requested by the land council for the parties, list this matter after 4 weeks. Okay,
Much obliged.
My lord, item number 32. I am for respondent number 4, private respondent.
okay,
And I have taken the consent and this also may be fixed after 4 weeks, Your Lordship. I've taken the consent of petitioner.
okay, Mr. B.V. Paul, land council for the respondent number 4. On the consent of the council for the petitioner, prays for listing this
After 4
matter
weeks.
after 4 weeks. The prayer is allowed. List is matter after 4 weeks.
Lordship, there's an interim, Lordship,
Oh, you are for?
for the petitioner, Lordship.
Okay. Mr. Wagner, no?
Laknepom.
And council for the petitioner is present, stop. In the interim order passed earlier shall continue till then, till the next date, okay.
Bless, Lordship.
Much obliged.
Okay, please, Your Lordship. I
Yes.
beg to mention, item number 26. Since my senior has some personal difficulties.
Yeah, for the petitioner,
Yes, Lord.
respondent.
For the state respondent.
Okay.
Lordship, let it listen after 2 weeks.
2 weeks. You are Mr.
Mr. N. Kerzer, on behalf of TKG.
Okay, appearing on behalf of P.
EKG.
KG, TKG, Land Council for the petitioner. Prays for listing this matter after 2 weeks. Mr.
On behalf of Tiba,
Okay. Land Council for the state respondent. Has no objection. The prayer is allowed. List this matter after 2 weeks. Okay.
Your Lordship, I'd like to mention on behalf of additional AG, V. Sokre,
Mm.
as she's indisposed, item number 20. Pray that the matter may be listed after 2 weeks.
30 is
20.
28.
20.
Okay, who is for the,
I'm for the petition, Your Lordship.
is it revision petition
Yes, revision.
or
petition.
not
Revision
appeal?
petition. Yes, not appeal, revision petition, Lordship.
Is it against the conviction only,
Yes, Lordship.
but we have filed in revision.
Revision, yes.
Appeal doesn't lie here.
Yes, Lordship.
Against the convict,
Yes, because the punishment
against
is,
against the conviction, huh?
yes, Lordship.
The punishment is 6 years.
6 years, Lordship.
Okay. Mr.
The blue mark.
Mr. And
Mosam Longkumer, on behalf of V. Sokre,
Sokre, huh? Who prays for
2 weeks.
listing this matter after 2 weeks? Stop, huh? As the Land Council for the petition has no objection, the prayer is allowed. List this matter after 2 weeks. Okay.
Much obliged.
Your Lordship, I have a similar prayer for item 40 on behalf of additional AG, V. Sokre. After 2 weeks.
So who appear here for the petitioner?
I'm appearing on behalf of the petitioner.
No objection.
No objection.
Okay, similar order, huh?
Your
The
Lordship, there's an interim in this
The
matter.
council will change. And then here, of course, in the last, the interim order passed earlier shall continue till next date. Okay.
May I please, Your Lordship?
Yes.
I would like to mention item number 14. 14.
14, 1, 4.
14. Yes,
14 just mentioned.
No, 14.
Okay. What item was mentioned just now?
40.
14
40.
or 40?
Yes.
Sorry.
The previous item was 40.
Yes,
and
yes. Right. So you are for here you are for,
Respondent number 1.
who is for the petitioner here?
Lordship, I'm appearing for the petitioner, Lordship.
Okay.
I
No
pray,
objection. No objection.
Lordship, no objection.
Mr. Miss.
Tushi Jamir.
Land Council for the respondent number 1 and Miss.
Mika, Lordship.
Okay. Our name should come first, huh? Land Council for the petitioner. On the request of the Land Council for the respondent, list this matter after
2 weeks.
2 weeks. Okay.
Right, Lordship.
At the request, huh? At the request. Okay.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 19.
1 night.
Yes, Your Lordship.
Make appeal.
Yes, Your Lordship.
You are for the petition.
Yes, I'm for the applicant.
Appellant.
Yes, Your Lordship.
Who is for the respondent?
Your Lordship, I'm for respondent 1 and 2.
1 and 2.
I'm for respondent number 3, Lordship.
No objection.
No
No
objections.
Okay. Miss,
Priya Krula,
hmm,
on behalf of V. Devnath,
when do you want, you said?
after 3 weeks.
3
weeks.
3 weeks. Okay.
Yes.
Praise for listing this matter after 3 weeks. Stop. Miss,
Ramboni,
Land Council for the respondent number 1 and 2 and Mr.
Sukajish, Lordship.
Council for the respondent number 3 are also present. Stop. List this matter after 3 weeks. Okay.
Please, Lordship.
Please, Your Lordship.
Yes.
Lordship, I beg to mention item 39. Lordship, I'm for the petitioner. And Lordship, the leading counsel, Mr. Takakichi, is actually indisposed.
29.
39. 39. So your lordship may be gracious if this matter can come up after 2 weeks.
Okay, Mr.
V Koza.
Who is for the respondent here?
I'm for the private response, 3 to 13.
Okay, Mr.
V Koza,
Land Council for the petitioner,
lordship.
praise for listing this matter after
2 weeks
2 weeks as a senior is,
is in disposed, lordship,
okay. is
because of some
indisposed.
health issues.
Stop, huh? Mr.
Ali Boscom, lordship, for the
Mm.
private respondents.
Okay, and Miss, no,
As Mary for the state.
Mary. Land Council for the states are also present, huh? As prayed for by. As requested by the Land Council for appearing on behalf of the petitioner, list this matter after
2 weeks, lord.
2 weeks, okay.
Much obliged.
Let's your Robert.
Yes.
I would like to mention item 24. So,
Okay,
let this matter will come up, next week,
next week,
next week.
okay. And the,
I'm for the petitioner, your lordship.
no objection,
No objection.
Mr.
I am Chen, your lordship.
Land Council for the petitioner is present, stop. Mr. Moam Chen, Land Senior Government Advocate. Request for listing this matter after a week. The prayer is allowed, list this matter after a week. Okay.
Much obliged.
My lord, please allow me to mention item number 3. I mean, we allow 3 weeks time to file affidavit in reply to the affidavit filed by the petitioner. I'm appearing for respondent number 2 to 5.
Okay. Okay, so you are for
I'm for respondent number 2 to 5.
2 to 5,
Yes.
okay. So you are for the petition,
Yes, my lord. Appearing on behalf of Mr. S. Huck.
okay. At the request of.
Okay, needs a vote,
Mr.
my lord.
Land Council for the respondent number 2 to 5. List this matter after
3 weeks.
3 weeks, stop. Mr.
Banay Konya.
Appear on behalf of the Land Council for the petitioner, okay.
First up, I'd like to mention item number 12 on behalf of Mr. Muaz Amir, counsel for the petitioner. Lordship, I pray that this matter may come after 3 weeks.
You are for the petitioner,
Yes, madam. Lordship, I'm for respondent number 1, 2, and 6.
okay. Mr.
Banay Konya.
Land Council for the petitioner. Praise for listing this matter after
3 weeks.
3 weeks, stop. Mr.
Mr. Kajish, lordship.
Land Council for the respondent number 1, 2, and 3.
1, 2, and 6, lordship.
1, 2, and 6 is also present. This matter after 3 weeks, huh?
Obliged, lordship.
Okay.
Yeah, please, your lordship. Your lordship, I'd like to mention hearing item 13 on behalf of the council for the petitioner.
1, 3.
13, yes, 1-3.
So enhancement of the punishment. This is criminal appeal.
Yes, your lordship.
This is not revision again. Okay, you are for the petition.
Yes, on behalf of Santiago, your lordship.
Okay. So you are for
I'm for respondent number 1 and 2 on behalf of N. Lungkuman.
Miss
Conley.
Land Council appearing on behalf of Mr. Santiago, Land Council for the appellant, praise for listing this matter after
2 weeks.
2 weeks. Stop. Mr.
Mr. Kajish, lordship.
For
1 and 2.
respondent number 1 is also present. Stop. List is as prayed for by the land council for the appellant. List this matter after 2 weeks. No?
2
or
weeks, 2
2
weeks.
Okay.
Obliged, Lordship.
Your Lordship, I have similar prayer, item 18 as well.
Hmm. Yes. This is revision. What do you want? When?
2 weeks, Your Lordship.
You are for the revision petition.
Yes, Your Lordship.
State. No objection. Okay. At the request of Miss. You are on behalf of
Yes, Your Lordship.
Santiago. Okay. Miss. Appearing on behalf of Land Council for Mr. Santiago, Land Council for the revision petition raised for listing this matter after 2 weeks.
2 weeks.
2 weeks. Okay. The prayer is allowed.
Okay.
List this matter after 2 weeks. Mr.
Much obliged.
Appear on behalf of sorry, the PP only. Okay, PP is also present. Okay.
Much obliged. Now, please, Lordship,
There are canon of judgment of the Honorable Apex Court also, wherein it is opined that any agreement, it is to be read toto. Now this industry department, all educated people, and they have categorically undertaken that in the event the project is diverted, then they will return back the land to me. Now, this is the case, Your Lordship, and they are not, they have suppressing the fact that that was under contingent contract. They have, they are now, they want to take or enjoy this compensation. This is the case, Your Lordship. Now, and this petition is for interim also, Your Lordship, not this IA, against the IA, that injunction order, which is temporary in nature. Against this is going on. And this, finally, this civil suit has not been disposed. It is still pending, and we are tabling on IA only. Now, Your Lordship, I beg to take Your Lordship this page 6, page 16, Your Lordship, Annexure 1 of my revision petition. From where this
Sell deed.
sold it?
Yes.
Should I read, Your Lordship?
Yes. So just a minute, huh?
Yes, Your Lordship.
For admission. On 15/12, you were also present?
Yes, yes, Your Lordship. The Honorable Justice Borua, he has almost took up the he took up the matter, and he had
Okay, so then.
and then this Chomukdima DC was directed to.
The lane, it is informed
Yes, Your Lordship.
that the lane have been acquired.
Yes, Your Lordship. Yes, Your Lordship. The land have been acquired, and
And if that be so, or the lane has been acquired, then it is a case of acquisition of land.
yes, Your Lordship. My contention is
Means
that.
suit would not lie.
My contention is that, Your Lordship, I am agreed with that,
Hmm.
that the industry department was not having title over the land. They have handed over the land, suppressing the fact that that sell deed was a conditional sell deed. Now, Your Lordship, this Annexure C, just 2-3 days back, this Chumokdima DC has submitted one affidavit.
Then made an observation also
Hmm.
that you have to take recourse
Yes,
to section 12 of the State Act.
yes, Your Lordship. Now, if section 12 is that 65 Act of this Nagaland Requisition and Acquisition Act in 65, where it is, then I have to approach this Deputy Commissioner.
Hmm.
That was the observation made by the Honorable Court earlier hearing, but no order has been passed therein. Then, yes. No, This honorable court, the section 12 is that, your lordship, that when the land is acquired, and if there is anything, then this deputy commissioner is to be approached. But here, your lordship, my prayer before this honorable court is that until and unless this title is settled, and this is a,
Until and unless the title is settled, then you are not entitled to claim the compensation also.
but your lordship, if the compensation is being taken by him, then to,
Now, whether the compensation already taken?
no.
Not yet.
There was a, this
Injunction.
injunction order.
That has also been vacated,
No,
you said.
but again, this honorable court.
Since my learned senior colleague has filed this case, for the sake of fairness, the stay of the vacation, the order that vacated the injunction, that is under stay, Lordship,
Okay.
for
okay.
now.
So that is when okay, the compensation amount has not yet been released.
Yes, your lordship.
Then,
It is lying with Kohima Deputy Commissioner.
affidavit filed, if there is any.
Affidavit filed by Kohima.
State has filed in compliance to the order my lord has just been reading, lordship.
Yes, yes.
1512.
State has filed.
Yes,
It is on record
yes,
by way of affidavit.
yes.
Okay.
And actually, your lordship, I have been served this on just 2-3 days back, I got it. And in fact, it was with my junior. And this morning I have gone through only.
Okay, pro forma respondent.
And
Deputy Commissioner is filed. Okay.
No, I agree with you.
What about the railway?
Railway is not here today,
Not here.
not here.
They, have they filed affidavit? No.
No,
For them, they have released the money, Lordship. Their role is, in fact, they have no role here, Lordship.
Okay.
and they have been arrayed as a pro forma respondent, number 2. And earlier, the Deputy Commissioner Dimapur was only,
Industries.
industry is the main respondent.
Have they filed?
Yes, your lordship.
Then the matter is ready for hearing. I think detailed hearing can be done.
Yes, your lordship.
No, Lordship,
Hmm.
this is purely a question of law. I have not filed any affidavit.
Oh,
It's a review
You-
application, Lordship.
Okay, you are representing?
The
Industry.
Industries and Commerce, Department of Industries and Commerce. In fact, as your Lordship has rightly observed, now, my Lord, that the question of whether right and title over the land is in dispute or not, that is not even a question of dispute, Lordship.
Mhm.
Sale deed was executed. It was registered before a competent authority, Lordship.
Mhm.
So the only question is, the first question, as my Lord has rightly mentioned, they have to first prove ownership. And that is by way of
Yes.
getting the rights and title over the land, Lordship. That even if it is sold to us, it is still theirs. They have to prove that. And that is one aspect of the matter. The second aspect is, Lordship, it cannot be said to be a conditional sale. And I have authorities to prove that, Lordship. Once the full payment, 100% payment is made, they have accepted the payment in 1985. Now, Lordship, any restraining condition that is absolute in nature, that is illegal, void, ab initio, Lordship. I have authorities also to prove that, Lordship. That purely on the question of law, Lordship. So in fact, it should not even take time to complete this case before this on the court. And there is urgency to dispose of this matter also, Lordship.
So this is clause 6. You said
Clause 6,
Just let us see.
page 16, annexure 1.
Just a minute, let us just see once. Clause 6.
In the event of the department fails to continue with the said project and if abandoned, the said land shall be returned to the landowner. It is crystal clear, your lordship.
And you have accepted this condition?
Yes, your lordship. They
Lordship,
are all
whether it
educated
is
persons.
accepted or not.
Hmm.
Now, as on today, the authorities also keep on changing. The authorities of today cannot take responsibility for what happened in 1985. However, my lord will appreciate this. Absolute restraint when in the matter of properties, lordship. Absolute restraint itself is void ab initio, lordship. So once the sale deed has been executed, contract no more lies, lordship, after the ownership is already transferred.
It is not correct that, your lordship. Ownership has not been.
It is not just a
stated,
matter of my submission, lordship. It is by the authorities that I will present before you, lordship.
It is a non-cadastral village land, your lordship.
So thereafter, what happened about the lane? So the lane does have any, this one, rec?
Then, your lordship, when the land is diverted from the project,
Hmm.
the cause of action arose from there.
And lordship, the question of abandonment is specifically mentioned. That question does not arise at all. Our farming is still continuing, lordship. This is a public project, public interest project, railway line, lordship. Can the department deny the land which is part of the railway line? Can the department or any private individual deny when the land is required for public interest, lordship? So, lordship, first thing is they have to prove their title and ownership over the land by by invoking the same provision as well as the acquisition that has been carried out by the Deputy Commissioner, lordship. That document was not with me. But lordship, they have to challenge that. That's the first step. The second step is, lordship, whether absolute restraint in an agreement is a voidable agreement or not. And that is, as I have submitted, your lordship, respectfully, that I have the authorities to prove before your lordship. And as far as the application of Transfer of Property Act in Nagaland is concerned, even if the law is not adopted by the State Legislative Assembly, lordship, there are authorities of the state of Arunachal also, lordship, where the spirit of law, the spirit, it cannot be said that the principle of law is not applicable. It is applicable, lordship. Absolute restraint. After accepting all the benefits way back in 1985, can they now come back and say that that condition is there? Once the payment is made, sale deed is executed, it is registered, lordship. The ownership is already transferred. After it is transferred, lordship, such condition, laying down absolute restraint itself is illegal, lordship, and it is void ab initio, lordship.
Ownership already transferred.
No,
Thereafter,
it is a
whether
village
it
land,
is
your
required,
lordship.
huh?
It is a village land, your lordship. I beg to take your lordship, section 31 of the Indian Contract Act. What is contingent contract? Section 31 of Indian Contract Act, your lordship. Your lordship, Indian Contract Act. What is contingent contract? And it is not correct that, your lordship, if it would have been a absolute sale, then why this condition has been stipulated there in it? Why this condition has
Lordship,
been
let my
accepted?
learned senior colleague finish his submission peacefully, and then I may also be allowed to be given the
Yes, yes,
opportunity to satisfy your lordship instead of intervening again and again, my lord.
So the consideration amount is, just a minute, huh? Citronella production. Okay, yes.
Now, your lordship, contingent contract that why they have incorporated this? This is Indian Contract Act. Now, when they have handed over the land to the for acquisition, suppressing the factum, from there this cause of action started. It may be the 100 years, it may be 50 years, no question. But they have categorically, and those who have signed this agreement, your lordship, all they are well educated. And they are not what it is called rustic villagers. They do not know the contents. It is not like that. Knowingly, they have come into contact that in the event of the department fails to continue the said project, and if abandoned or abandoned not, and the conjunction is by and abandoned, whether if the fails to continue the project, and if abandoned, the said land shall be returned to the landowner. Why they have incorporated? Why they have entered these conditional deeds? Fails to continue the said project.
The project is.
Project is Citronella project, and your lordship.
Citronella production farm in the following terms.
Yes, your lordship, and if your lordship kindly peruse the affidavit I have received now. There it is annexure C.
Just a minute. Now, can you just kindly read to clause 2 also? You have read clause 6. Clause 2.
Clause
Of the
2.
same
I
page.
hereby authorize the concerned department to the aforesaid land in any manner as they like, and I shall have no right and claim to interfere in any way against the said land at any time. Any of our local heirs representative shall have no right to interfere with the said land, virtue of the said sale deed. Now, if how long the Citronella project will be continued, then my heirs and successors, they will not have any right to interfere. But Citronella project has been diverted for other project, for railway line. So now, your lordship, logically.
Is it the entire land or?
No, a portion of the land has been
portion of
taken.
the land?
And if your lordship kindly peruse this recent NHRC of the state governments, it is categorically Department of Industries, this
Annexure C?
NHRC of the government affidavit. Last one, your lordship. C.
Government is respondent number 3.
Performer respondent number 2. No. Chumokdimai.
Is a performer respondent number 3.
Performer respondent number 3. Annexure C of their affidavit. Just I have seen. Last page.
Yes.
Now there are 4, 3, then 4 column. 4. Ordinary tree, certain number, and citronella plant. There was citronella plant, your lordship. And the land where the citronella plant was there, it is being given to the railway.
By the way, railway,
My lord.
for what purpose it was given to?
Railway line.
Railway line. Okay.
So it is other project, your lordship. Am I not entitled for compensation as a title holder of the land? Under a contingency, under a contingent contract? And it is clear, your lordship, Department of Industries Commerce, Citronella plant, 12,50,000 against this Citronella plant. So it is categorical. the project land was handed over to the railway. And in the sale deed, conditional sale deed, industry department has agreed and accepted the terms that in the event if abandoned or project is diverted from the project and abandoned. So they have diverted from the project, Satanala. So your lordship, title is to be proved before the original court where this civil suit is pending.
Yes.
And this is where we are traveling only on IA, which is temporary in nature. I am also having several rulings where the Honorable Apex Court has held that an agreement, it should be read the contents therein. And it is not that this industrial director or others who have signed this agreement, district industries, director industries, and he is not a layman. He is well educated. He knows the English, and he knowingly he has signed this on behalf of Government of Nagaland purchaser. And witnesses by ESC Medjifema.
So this industrial has not filed affidavit.
Not filed.
Let the industry file.
No,
Can we
Lordship-
pass order?
No, Lordship,
Yeah.
filing of affidavit is not required. It's purely on a question of law. All the documents,
Yes.
the earlier proceedings are all there annexed with this
Who
present
appeared for
review
industry?
petition. I'm appearing for the industries, Lordship.
Okay,
So Lordship, there is no requirement for filing any affidavit.
not required for filing.
Yes, Lordship.
Okay. So, this is by the pro forma respondent.
Yes.
By
The
the
direction
direction of this honorable court,
with the direction.
on whether the acquisition process was carried out as per the law or not. And it turns out that yes, the process was carried out as per the law, Lordship.
Actually, your lordship will appreciate that this affidavit is being filed, annexing only one notification, and
Yes, yes, this is.
so here, your lordship, I require some instruction to be obtained from my client, whether they were having this knowledge of this notification or not. No paper clipping has been annexed. Then in that case, your lordship, I require some time to get instruction from my client. Otherwise, I cannot take the risk on that. My client will charge me. "Arey, you should have.
In any way, Lordship, they have not challenged this. They were aware that the acquisition process, the
No, no.
requisition and acquisition process was going on at that point of time. This is not only plot of land under the village of the petitioner, Lordship. They were aware. So why they have not challenged this, Lordship?
No, your lordship, I have to take some instruction in the
This
event.
was in the 2014.
Yes, Lordship. The entire area of the village land was under requisition and acquisition at that point of time, at that point of time, Lordship. How can they say that they are not aware?
No,
Have to
I'm not
challenge
telling,
those.
I'm not telling, I'm not aware, your lordship. I am telling that I am praying before this honorable court that I have received this and
In any manner,
going through
Lordship,
this.
without
going through
challenging
your
this,
lordship, this is
both
a
the suit
half-done-
as well as the present petition is
It is a half-done-
infractious, Lordship.
half-done thing, your lordship. So I request, I have to, if my, without his consent, I cannot also say that, no, I know that only. It is the factum that there is no paper notification, nothing. And as a counsel, I cannot take that risk also. Then I should take at least an instruction from him. Tomorrow it can be fixed, no problem. Because I have to take instruction now.
Unless my lord is leaving tomorrow, it's okay, we can take up tomorrow.
Or when,
Tomorrow.
So these notifications you have not challenged.
I have to take instruction, your lordship, because I am I am from the stage of filing this.
This was notified.
Yes. And there is no paper clippings. If there would have been any paper clippings, then I should, I could have taken that risk. But here this notification, whether then no, it is a question of factum to be obtained from the client. And I cannot take up the risk, Your Lordship.
If my lord is still staying back for another week, then we can fix tomorrow, lordship. If not, in fact, it's a very short matter, my lord.
Hearing is to be
Limited
taken,
question
please,
of
Your
law,
Lordship.
The order. Hmm. You have to take recourse of the section 12 of the Act 1965.
Is it possible for your lordship to take up this matter tomorrow morning?
Just a minute. So,
Now, section 12, Your Lordship,
hmm,
it says that reference to court.
Hmm.
The collector shall in every case where only person aggrieved by an award made under subsection 2 of section 11 make an application requiring the matter to be referred to the court. Where there is any disagreement with regard to the compensation payable under subsection 3 of section 11 of the application, on the application of the person entitled to compensation requiring the matter to be referred to the court. This is section 12 is pertaining to the matter referring to the court. Now, Your Lordship, basically, Your Lordship, here, Your Lordship, this title is in. So, Your Lordship, I cannot take the risk. Now I have to get some information because this is also a.
you received the copy.
Yes, just received the copy. Actually, with all fairness, it was up to my junior, and today I have come first, and I have received this today. And it was filed on 23rd. And today I have received, and I have to take instruction, Your Lordship.
Okay. Mr. P.B. Paul, Land Council for the petitioner. Who submits that he had just received the affidavit.
Next.
Filed by the proforma respondent. And prays for some time to obtain instruction. Stop. Who appeared for respondent number 1 and 2? For 1 and 2.
Number 1 and 2.
2 is not there. Proforma 2 is not there.
The railways.
Mr. Correspondent number 1 is?
Number 1 is Deputy Commissioner Dimapur.
So who appeared for him?
I'm appearing.
Okay, Mr. Direct counsel for the respondent number 1. You are only for 1.
No, I think for respondent one.
Respondent number 1 and 2, the main respondents, I'm appearing on behalf of the respondent number 1 and 2, lordship.
Okay, Mr.
I'm proforma respondent.
Okay, you are performer respondent. Okay. Learned counsel for the respondent number 1 and 2. And Mr. Angami. Learned appear on behalf of the learned government advocate for the respondent number, pro forma respondent number
1 and 3.
1 and 3 is also there.
Your Lordship, the newly pleaded Deputy Commissioner
Newly pleaded.
Chumukedima. It's not in the main petition, Lordship.
By the order of the, I have filed again this recast also, Your Lordship. There are two set of petition.
That is why.
The money is now lying with Chumukedima.
Okay.
It is bifurcated, the district.
For 1 and 3, huh? And this NF railway,
NFL and non,
no one,
non. Pro forma, respondent number 2.
no one appears on behalf of the performer respondent number 2.
Yes, Your Lordship.
So you want this matter?
Your Lordship, I have taken the consent on 13 February. Because if I do not get my client, then again it will be tomorrow it will be. On 13th,
Lordship.
I have taken the consent from my learned
Madam,
junior colleague.
Okay.
Lordship.
At the request of the learned counsel for the petitioner,
My lord.
which has been accepted. Sorry, which has been learned counsel for the petitioner. List this matter on
13th, 13 February, 13 2.
to which the learned counsel for the respondent has no objection. Stop. List the matter on 13 for admission. We'll try on that day then.
Yes, my lord.
Okay.
My lord.
Bless you, Lord.
Much only.
From
I was having interim also, Your Lordship.
the interim order passed earlier shall continue till then. Okay.
Much obliged, Your Lordship.
From the supplementary cost is for motion item number 42.
Yes.
Yes, may I bless Lordship. Lordship, with this criminal petition,
Hmm.
the petitioner is challenging the order dated 11/12/23 passed by the Chief Judicial Magistrate, whereby the criminal complaint lodged by the petitioner was dismissed illegally, Lordship. Before referring to the impugned Lordship, short facts is that, Lordship. In the year 2004, the petitioner and the respondent entered into a partnership deed to deal with the business of supply of medicines and drugs in Dimapur, Lordship. One of the terms and conditions in the partnership deed is that, Lordship, no partner shall sell the shares without the consent of the other partners. However, Lordship, the respondent 1 and 2, without the consent of the petitioner, Lordship, gifted their shares to a third party, in violation of the terms and conditions of the partnership deed. Therefore, Lordship, the petitioner lodged a criminal complaint before the Chief Judicial Magistrate, Dimapur, which was registered as criminal complaint 26/2017.
Selling of the share, attract the criminal case.
Lordship.
Okay.
Therefore, I lodged a criminal complaint of 26/2017 before the CGM Dimapur. Lordship, after filing the criminal complaint, what happened is that, Lordship,
Criminal complaint under what provision? What offense or section?
for Lordship, for jailing and criminal breach of trust
Okay.
by the respondent. After lodging the criminal complaint, what happened, Lordship? The respondent an order to safety scan, Lordship, manufactured a document, affidavit allegedly signed by the petitioner. Although petitioner never executed that affidavit, whereby it has been stated in the affidavit that the petitioner have considered for sale of shares.
Okay,
Therefore, Lordship, the petitioner can lodge a complaint.
there is a forgery only.
Another complaint, Lordship,
Okay,
before the judicial magistrate first class, which was registered as criminal complaint 12 of 22,
second criminal complaint.
second criminal complaint. The legality of the affidavit allegedly signed by the petitioner is prejudiced before the Chief Judicial Magistrate First Class Timabo and Criminal Complaint 12 of 22. However, Lordship, by the MPU order, my criminal complaint 26 of 2017 was dismissed on the ground
The
that
first one.
on the ground that the dispute has already been settled by the affidavit dated 15/6/2015, against which a criminal case 12 of 2022 is pending before the Judicial Magistrate First Class. Therefore, the reason and the conclusion arrived by the Chief Judicial Magistrate in dismissing my first criminal complaint is totally illegal. Because
Yeah,
the
but
affidavit,
Chief Judicial Magistrate, before the Chief Judicial Magistrate.
yes, Lordship.
So the second complaint was lodged before the Judicial Magistrate First Class.
Yes, Lordship.
Okay, so whether in the second one, the document against which you have lodged criminal complaint before the Judicial Magistrate First Class, whether this this document was also produced before the Chief
Yes,
Judicial
Lordship.
Magistrate.
Yes, Lordship.
Okay,
So without considering that, Lordship, my criminal complaint was dismissed by the MPU order.
on what ground?
On the ground that by the affidavit which legality of which document is pending before the Judicial Magistrate First Class, by the document dispute has been settled. That is the conclusion arrived by the Chief Judicial Magistrate. That is the conclusion arrived by the Chief Judicial Magistrate in dismissing my criminal appeal 26 of 17th.
This conclusion is
Lordship, in fact, the Chief Judicial Magistrate should have waited for the outcome of my criminal complaint 12 of 22, which is pending before the Chief Judicial Magistrate First Class. Because
now this document, the second one against which you have lodged complaint before the JMFC, whether this document was who presented this document?
Lordship,
CJM?
I placed the documents. I placed the CGM, Chief Judicial Magistrate. Another criminal case is pending before the Judicial Magistrate First
Whether
Class.
that has come on record.
Case, Lordship,
This fact, the another criminal complaint
yes.
is pending before the JMFC. Whether this has come on the record of the order passed by the CJM.
Yes, Lordship, it is there.
Okay.
That affidavit has been referred in the impunity order, Lordship.
Okay, so let us just see the.
Lordship,
operative
kindly
portion
do
of-
the MPU order, Lordship. Page 70, Lordship,
70.
70.
Okay, this is before CJM. Okay,
This is CR 26 of 17th.
this is before the CJM.
CGM, Lordship.
The order impugned is, okay, the complaint, criminal complaint
Yes, Lordship.
before the JMFC is still pending.
Yes, still pending. Lordship.
Okay, so what is the ground of the,
Lordship, all the
Dismissal.
Lordship directly to the grounds taken by the CGM, Lordship. Page 73.
yes,
Taking into consideration, Lordship, last paragraph, Lordship.
Hmm.
Taking into consideration the inquiry report, the statement of the complainant, the other material evidence placed on record, and the section of law under which the instant criminal complaint petition is filed against the accused person, it is evident that the allegation level against the accused persons are not made out in as much as the affidavit dated 15/6/2015. This, the legality of this affidavit 15/6/2015 is subjudice before the judicial magistrate first class, Lordship.
Hmm.
It's a clear indication of the fact that the complainant had also consented to the handing over of the shares and interest of the partnership business by accused person to Shri So. Hence, the confirmation of the terms and condition, particularly number 20, 29, and 30 of the date of partnership, that is 7/7/2004, does not arise, warranting prosecution of the accused person under section so. And second point, Lordship. More so, point number 27 of date of partnership dated 7/7/04 makes it abundantly clear that any dispute between the parties in regard to the partnership business or as regards the interpretation of any clause or the date of partnership shall be referred to and be decided by the arbitration. Lordship, the criminal complaint.
There is arbitration clause also.
Yes.
There is arbitration clause also in that.
Yes, Lordship, arbitration
Okay.
clause. But, Lordship, the complaint which was lodged before the CGM is the allegation of offense of jailing, Lordship, and criminal breach of trust.
Okay, where this CJM has referred about this 15/6/2015 affidavit in the body of the orders?
No,
Impugn order?
not referred.
Nowhere referred.
No.
Okay,
The CGM has mentioned about the affidavit.
you have submitted this document by way of what? Before the CJM? You have presented this document
Yes,
who?
Lordship.
In your complaint petition?
No, because Lordship, this affidavit dated 15/6/2015
Hmm.
has been manufactured after filing the criminal petition, Lordship.
Manufactured, but who has submitted this document, I'm asking? Who has submitted this document before the CJM?
By the respondent.
By way of what?
That I cannot say, Lordship. That is how the CGM has read about this document.
Where is the evidence recorded or the examined? The petitioner was, the complainant was examined.
Yes, Lordship.
Okay.
Lordship, may kindly see.
At the time of examination, this document was not there.
No, Lordship.
Okay.
In the first criminal case.
Whether the alleged accused person were also examined.
Lordship. In which, in
In
the
this
first
CGM
criminal
case.
case.
Before the CJM.
Lordship, inquiry was conducted as per section 202 of CRPC.
Okay, they were also examined.
Inquiry was held by the police officers. And based on the inquiry.
It was directed to the police.
Yes.
Okay.
In terms of section 202 of CRPC. Because they are residing outside the jurisdiction of the CGM.
Whether the police has submitted any documents?
It is reflected in the imbued order, Lordship.
Hmm?
I'm not aware. It is reflected in the imbued order.
Where do we find that?
Page 73, taking into consideration of the inquiry report.
Hmm?
Page 73, Lordship, last paragraph.
Inquiry report.
Yes.
So whether, we need to call record then. Okay. So you are not aware of the inquiry?
No, Lordship.
Okay.
So at this stage, Lordship, notice may be issued to respondents.
Yes.
And in the meantime, record may be called for.
Mr.
What is the
What is the mean? Not council for. the petitioner. Stop. So it is only the private respondent.
Yes, private respondent. 1 and 2.
Okay. Para. This is an application under section 482, read with section 397 and 401 of the Code of Criminal Procedure 1973, filed by the petitioner, praying for quashing of the impugned order dated 11/12/2023, passed by the Line Chief Judicial Magistrate Dimapur in CR case number 26, 2017. What is the ground taken by you?
Lordship, my grounds, first ground is lordship. The legality of the affidavit dated 15/6/2015 is prejudiced before the judicial magistrate first class in another criminal case. Therefore, the CGM, taking into consideration of that affidavit in dismissing my criminal complaint, is totally illegal, lordship. And secondly, lordship, the reason taken by the CGM in dismissing my criminal petition that there's a clause for reference to the arbitration. Because lordship,
Okay. Okay. Issue notice. Returnable by 4 weeks. Stop. Call for a court. The petitioner shall take steps upon
respondent 1 and 2.
the respondent number 1 and 2 by a registered post with AD within
3 days.
3 days from today. Stop. List is made after
4 weeks. lordship.
4 weeks. Okay. Okay.
Okay.
For admission, item number 2.
Replace your lordship.
Yes.
A criminal complaint was filed against the present petitioner in the court of CGM Kohima. During the pendency of the complaint, the parties have arrived to a compromise. And then the matter has been compromised.
Okay.
Pursuant to the compromise, an application was filed by the present respondent before the JMFC Kohima.
The case is pending before the JMFC.
Yes.
Under
and-
under what offense?
JMFC.
What are the offense alleged against
Paragraph 4.
accused petitioner? Paragraph 4 of,
The revision petition, page
Okay.
4.
this is revision.
Yes, Lordship, for question. It's an application under section 482.
Revision, this is revision. Paragraph 4.
Yes.
Three 379, 409.
Yes.
So,
During the pendency of this case,
Hmm.
the parties have arrived to a compromise.
okay. This
And
is
then-
this is non-compatible, it appears.
Pursuant to that, an
Hmm.
application was filed by the present respondents
Okay.
before the JMFC
Hmm.
to close the case. But then there was one section that is 409, Lordship is well aware.
Yes.
Since this section is non-confundable,
Hmm.
the learned court below said that since although it is compromised, one of the sections is non-confundable. On that ground, the court wanted to proceed with the case. And thereafter, agreed by that, the present application has been filed.
This is complaint case only.
Yes.
Okay.
And during the pendency of this present case,
Hmm.
this honorable court on 12/12/2023
Hmm.
has passed an order directing the both the parties to file a joint affidavit to ascertain the veracity of the compromise, whether it is really compromised or not.
Okay.
So accordingly, the joint affidavit has been filed by both petitioner and the respondents pursuant to the order dated 12/12/2023 passed by this honorable court. And then the affidavit is under record, Lordship. A similar case before the same court,
Hmm.
day before yesterday, that is 30th January 2024,
Hmm.
this honorable court has passed an order. Because in that case also, there were two sections,
Hmm.
279 and 336, which were non-commutable sections. So under same ground, the same court has proceeded with the case. But then the petitioner approached this honorable court and then submission was made by relying on the two judgment of the apex court. And since the matter is a civil nature, which is not a heinous crime, so this honorable court under 482 can quash the proceeding since the parties have already compromised. So in view of that, the order was passed by this honorable court. So this is in order to maintain the judicial discipline. I believe a similar order may be passed in this case also. Here, the non-commutable section is section 409. But as I have submitted, Lordship, it is a civil dispute, a complaint, and the parties have already compromised. A joint affidavit has also been filed by both the parties about the compromise. And then this honorable court has also passed an order in a similar case. This is in the same court, JMFC Kohima. And then I'm placing a copy of the order before your Lordship.
Yes.
And the relevant portion, paragraph 7, where this honorable court talks about non-commutable sections. Paragraph 7. It is submitted that the above compromise deed dated 2/4/2023 and the affidavit dated 10/10/2023 were submitted before the learned court of JMFC Kohima. However, since some of the offenses charged against the accused persons, section 279, 336 IPC, are non-commutable offense, the petitioner has filed this instant criminal petition praying for quashing and setting aside the GR number 47/23 under section 279, 336, 337 IPC, lit with 184 MV Act pending before the learned court of JMFC, Kohima, Nagaland. And then the apex court ruling has also been referred to. But the relevant portion, I would like to refer to your Lordship. That is paragraph 15, 16, and 17. The finding. May I read, Lordship? Starting from paragraph 15. The ground pleaded by the three petitioners herein, that is informant, victim, and two accused persons supported by the settlement date dated 2/4/2023 and 10/10/2023, executed in presence of the competent witness before the
Yes.
competent authority, reveals that the accused persons have already paid adequate compensation to the victim for his treatment, and the victim side has also no further grievance against the accused persons. Considering the facts and circumstances of the present case, this court is of a considered opinion that the origin of the dispute is in the nature of a personal dispute. In the given factual background, the commission of offense shall not have a serious impact on the society at large. Inasmuch as the entire episode arose out of dispute which are private in nature, the offenses in the given facts cannot be treated as heinous and serious offense of mental depravity as could be discernible as gathered from the materials collected by the IO of the case during the investigation. Therefore, the ends of justice would meet in quashing the criminal proceeding being GR number 47 of 2023 under section 279, 336, 337 IPC, read with section 184 MV Act, pending before the learned judicial magistrate first class Kohima, Nagaland, arising out of Kozamas PS case number 4 of 2023 under section 279, 336, 337 IPC, read with section 184 MV Act 17. In view of the above, this criminal petition is allowed. Accordingly, the criminal proceedings against Sri so-and-so, being chair number 47 of 2023 under section 279, 336, 337 IPC, read with section 184 MV Act arising out of Kozama PS case number 4 of 2023 under section so-and-so, pending before the learned judicial magistrate first class Kohima, Nagaland, including the charges order is set aside and quashed. Now, in that case also, the same ground was taken that two sections are non-commutable. Therefore, I cannot close this. In view of that, the proceeding was proceeded. In our case also, the compromise was already arrived on 8 September 2023. By enclosing this compromise deed, Lordship will find at page 103. 105.
105.
Yes, this is the compromise deed between the parties.
Okay. $105.
Yes.
Okay.
May I read or?
No, it's
it will
okay.
suffice?
What the relevant person where they have stated that they have come into the amicable settlement, where is the relevant person just so
In the light, page 106.
106. Okay.
And whereas a thorough deliberation, the first party and the second party have mutually realized and deemed it best and convenient to compromise the matter in an amicable manner in order to avoid a protracted litigation and for the welfare of the community as a whole. In the light of the above, the first party has decided not to press the charges against the second party in order not to frustrate the cause of justice. The first party is no longer aggrieved with the issues raised in the criminal complaint number 4 of 2023 and the ensuing FIR number so-and-so.
This was signed on which date?
It was signed on 8th day of September 2023.
8 September. Okay.
Yes.
Compromise.
And the complainant has signed.
Have you also annexed a complaint?
Yes.
Complaint petition?
Yes.
Where do we find?
Complaint petition is at page 16.
Okay. So this is basically raising. You are for the respondent. You are in the complaint.
Yes.
Your respondent number?
I'm respondent number 1 and 2.
Okay. So this complaint is basically complaint.
This is criminal complaint case number 4 of 2023.
Where is the allegation in short brief, we will find the allegation against you.
Allegation against me.
Page 19.
19. Page 19, paragraph 4. To accept a case.
This is the brief allegation against you.
Yes, yes.
Paragraph 4. Okay. So the trial, the court has started the proceedings in the JMFC after the receipt of whether the cognizance taken.
He has directed the officer in charge, Semenu Police Station,
Okay,
to investigate the case.
okay, directed. And whether the
Yes,
police
direct-
has investigated into the case.
yes. Investigated.
any
And
report?
during that time,
Uh,
the compromise has been arrived
Whether,
between the
whether in
parties.
the meantime, the police has also submitted report,
No, not yet,
not yet.
not yet.
Where is the direction to the police?
Election. This is. You can order. This JMFC's order is at page 98, 24/5/2023. Relevant portion is at page 100, second paragraph,
Page 98. Page
page 100.
100.
It starts from 98, but 100 will be relevant. That is,
Okay.
operative portion is in the second paragraph. In the light of the facts and circumstances, the OC Revenue PS is directed under section 156, clause 3 CRPC to register an FIR at the Revenue
Okay,
PS.
this is order sheet,
Yes,
order sheet, order pass
Order-
124.
yes, of the JMFC.
Pursuant to this, whether the police has registered,
Yes, 101.
just a minute, huh? One zero one.
Yes.
This is under police has registered PS case number, this one. This is so many sections.
Yes.
Which are the section which is not non-compatible here
409 Lord.
only?
Yes.
Otherwise rest are compatible.
Compatible sections and 120, 120P is both
If it-
compatible and
with the-
non-compatible.
If it is with 409, it will be non-compatible. Okay. 34 also. Register and investigated into. So this was on which date? 5/23. Must have completed the investigation also. Police. it was registered, must have completed the investigation also.
I have no knowledge about whether it is completed or not.
So whether the charge
But
sheet has.
then thereafter,
Hmm,
on 8 September 2023,
hmm.
the compromise was arrived, 105, which I have just referred to your lordship.
So this compromise is on, and compromise the deed was executed on which date?
8 September 2023.
Okay, that means.
And then
that is
thereafter,
after about, this was on, in the month of May,
yes,
registered,
yes.
June, July, August, September. So now after this compromise petition, whether the petitioner has submitted this compromise petition before the police.
Yes, lordship. The respondents,
Hmm.
lordship, may kindly come to page 108. Representation for withdrawal of complaint, FIR. That is at page 108. It was submitted to the officer in charge and the
Page
IO,
108. Hmm.
15 September 2023.
Listen. Okay,
And relevant portion, lordship, may kindly just turn to page 110 for a moment. Last paragraph, 110, last paragraph. 110,
okay,
last paragraph. May I read?
yes.
Keeping in mind the welfare and unity of the 6 villages and for preservation of peace and harmony among the communities, the undersigned resolved not to praise churches and pursue the matter again in the honor of executed undertaking dated 19 August 2023 and compromise deed dated 8 September 2023. In the light of the above, the complainant undersigned in good faith and honoring the wishes of the leaders of the 6 villages withdraws the complaint in FR number 0016 of 23 dated 29/5/2023. This is what lordship has just seen. GR number 80 of 2023 under section so and so, read with section 34 arising out of criminal complaint number 4 of 2023 before the Honorable Judicial Magistrate First Class Kohima, Nagaland. And then the 2 complainants have signed. And after this, the court has passed the impugn order,
Okay, which one?
page 112.
Impugn order?
Yes.
Okay,
It's dated 28/9/2023. May I read, lordship?
yes, yes, please. Yes.
Learned Counsel, K.C. Mary, present for the complainant in chair number 4 of 2023. Learned APP, Sashi Mongla, present for the state. Learned Counsel for the complainant has filed IA 173 of 2023, praying for permission to withdraw the criminal complaint number 4 of 2023 on account of the matter being compromised between the applicants and the accused persons. It is submitted that during the pendency of the investigation, the parties have compromised, and to that effect, an undertaking was executed between the parties and the village leaders under the County Village Forum comprising of 6 villages, namely, and the name of the villagers are shown. It is further stated that a compromise deed was executed between the complainant and the accused persons in line with the above mentioned undertaking. In view of the above, considering the welfare of the 6 villages and the preservation of peace and harmony among the community, it is prayed that the GR case number 4 of 2023 be allowed to be withdrawn. Learned PP, per contrast, submits that the GR number 80 of 23 arose out of CR number 4 of 23, and that since the GR number 80 of 2023 is yet to be charged, it is premature at this stage to consider a prayer of the applicants. It is further submitted that some sections under which the accused persons are booked are commendable. However, some churches are not commendable. As such, it is submitted that even if the court takes the compromise deed to consideration, since some churches are non-commendable, the said non-commendable sections cannot be compounded. So that is the basis, lordship. Further, since investigation is still ongoing, it is submitted that there is possibility that charge may even be altered when the charge sheet is submitted. It is thus read that the application may not be allowed at this stage and be considered as and when charge sheet is filed. Record shows that CR number 4 of 2023 was filed by the complainants on 12/5/2023. However, by order dated 24/5/2023, this court has issued direction under section 156 clause 3 CRPC to the officer in charge of Seminyu PS to register an FIR at the Seminyu PS under appropriate section of law and immediately take steps for effective, unbiased and expeditious investigation in regard to the allegations of misappropriation of public fund that has been alleged as to have been committed by accused 1 and 2. Accordingly, Seminyu PS case number 16 of 23 was registered under section so-and-so, and the case was endorsed to Khusa Chori, SDPO Seminyu for investigation. Consequently, by order dated 27/6/2023, the CR 4 of 2023 was kept in abeyance as per section 210 CRPC till the filing of the final GR form GR number 80 of 2023. Further, on perusal of the case diary submitted by the IO, it appears that the IO has been conducting an effective investigation till date and has examined many witnesses, materials to the case, as well as called for the records from the authorities concerned in connection with the case. The present application is being preferred on the ground that the matter has been compromised and in the interest and harmony within the community. Herein, this court is inclined to rely on a citation given. It may also be further noticed that even in section 3 of section 156, the only power given to the magistrate who can take cognizance of an offense under section 190 is to order an investigation. There is no mention of any power to stop an investigation by the police. The scheme of these sections thus clearly is that the power to investigate any cognizable offense is uncontrolled by the magistrates, and it is only the cases where police decide not to investigate the case that the magistrate can intervene. Further, reference is made to Kananilal Agarwal versus State of so-and-so. Once the learned magistrate gives such a direction under subsection, the police takes cognizance of the offense and starts investigation. The magistrate, having directed such investigation, cannot tinker or hamper with the investigation stated by the police by a subsequent order or recall of his order under section 156 clause 3 CRPC. If he does so, as was done in the present case, he exceeds his jurisdiction and acts in a manner which is not in accordance with the procedure established by law. Thus, while bearing in mind the developments that took place as was submitted by the applicant by virtue of the authorities of law mentioned above, it is amply clear that this court has no authority to stop the investigation in GR number 80 of 2023. Further, since the CR number 4 of 2023 has been kept in abeyance, awaiting the final form in GR number 80 of 2023, as per section 210 CRPC, the CR 4 of 2023 cannot be allowed to be withdrawn at this stage. In view of the above, the prayer of the applicant stands rejected. The undertakings and the compromise date may be taken into consideration at the appropriate stage and record in the final form. IO is directed to expedite this investigation and submit a final form at the earliest.
Yes, that is true.
So
That is true. The magistrate doesn't have a power thereafter. And then now we do not know what is the status of the investigation of the case.
Lordship, yes,
that
I
is-
do not know.
That is true. But then the difficulty is only with the case before the police, which is under investigation.
Yes.
So how to stop that?
But Lordship, when the parties have already compromised, when the complainant himself has withdrawn the complaint, what interest the court has
after
to go
endorsing-
ahead?
After
with the-
referring it to the police, endorsing it to the police, whether the IO has examined the parties, also the informant, already
Yes.
already recorded his statement.
Statement has been recorded, Lordship.
Okay, so in the statement, probably they have implicated the present petitioner.
No, Lordship,
In the
this is
statement.
with regard to the construction of a building, the
Yes.
girls' hostel.
Hmm.
The complaint has been filed on the misconceived notion that the hostel has not been constructed.
Hmm.
But it so happened that when the 6 villages, that is a range, the union.
Hmm.
They were about to construct a building for the union.
Hmm.
And when the foundation has already been done,
Hmm.
and then the sanction for construction of the hostel came.
Hmm.
And the building has been constructed, but after completion of the building, nobody turned up to stay in the hostel.
Hmm.
Therefore, this building has been used as classrooms for the school because it is adjacent to the playground. And the government school has been utilized, some rooms have been utilized, since no hostelers came and stayed there, because it is little away. And to construct the hostel,
It is fine, it is fine. So since party has entered into an amicable settlement
Lordship,
and agreed to withdraw and
Yes.
by filing joint petition.
Lordship.
But the only difficulty here in this case is the case pending before the investigating agency, the IO of the case. So we need to know the status of the case. And if this IO, because you have also submitted this application before the IO also. Since
They have submitted.
They have submitted.
Yes.
So we need the present status of the.
Lordship,
Hmm.
during the,
Be-
after the matter was filed before this honorable court,
Yes.
this honorable court on 12/12/2023
Hmm.
has directed both the parties to file a twin
That's right,
affidavit
that's right.
also.
To that extent, of course, that's correct only. That will be done only, but the difficulty is only whether the investigation carried out by the IO can be stopped at
Lordship,
this stage.
by, in view of the compromise date, this honorable court as well as the ethics court, the ratio laid down in a case like this, where the offense are commendable.
No, that is, of course, in that case, and in that case also, in the Supreme Court where it's referred also there, the case has already been charge sheeted. Case was pending before the court. But then here is a case where the case is still under investigation. No final report, no charge sheet, not yet submitted, we do not know. The police may also submit in the form of final report also.
What?
Because subsequently, both the parties.
Lordship, my learned friend is also assisting me with a citation.
Okay, yes, if.
I am furnishing with that, no? During the investigation, whether court can,
Yes, that clarification we require.
yes,
So.
page 290. Just the head notes, just in the second paragraph, health. The sentence starts with health. Second paragraph, Lordship, just below the head notes. Health, the principles on this point relevant to this case are that where offenses are predominantly of civil character, particularly arising out of a commercial transaction, dispute should be quashed when the parties have resolved their disputes. Further, timing of settlement would be crucial for exercise of power or declining to exercise power. Where, this is important, Lordship, where settlement is arrived at between the parties immediately after commission of offense and matter is still under investigation. High Court may be liberal in accepting settlement to quash proceedings, investigations, as investigations is in its early stage and charge sheet has not been filed. So I think
I
that
thought maybe
that will answer the
liberal. In
query.
accepting the settlement to quash.
Thank you. Lordship, again, kindly come to page 292, the same document. Paragraph 3. Paragraph 3, from the bottom, 4 lines. Paragraph 3, just above paragraph 4 lines. The sentence starts with thereafter. Thereafter, on 2/8/2012, he also lodged FIR bearing crime number 267 of 2012 with so-and-so police station for the offense punishable under section so-and-so. And then the settlement was done on 2/11/2012. 2/11/2012, paragraph 4. Now, can we come to paragraph 6 and 7? That is next page, page 293. May I read, Lordship? Paragraph 6. Insofar as the first reason given by the High Court is concerned, the learned counsel appearing for respondent number 2 made a categorical statement before us on instructions from respondent number 2 that he has in fact settled the matter on terms which are being taken note of above. He has further stated that respondent 2 has no objection if the proceedings arising out of the proceed FIR are quashed. We find that the matter is settled by the complainant out of his free will.
No, he has further
And
said
then
that
paragraph
respondent
7.
2 has no objection if the proceedings arising out of the aforesaid FIR are
Quash. Yes, we find that the matter is settled by the complainant out of his free will. Number 7, in a case like this, because like our case, where the proceedings are still at initial and nascent stage, High Court should have exercised its discretion in quashing the proceedings. Law in this behalf is well settled by a catena of judgments of this court and then the other rulings are shown, Lordship. The Apex Court ruling are quoted under paragraph 7, Lordship. Thank you. I believe this will cover the present case also, Lordship. It's in the nascent stage, in the initial stage, where the charge sheet has not been filed, when the case is under investigation. But if the parties arrive to a compromise state, then this honorable court can interfere with the complaint, Lordship. The complainant is no longer agree, and the compromise was arrived for the welfare of the community. So if the court still wants to go with the investigation, that means court doesn't want the welfare of the community. And court still wants to linger on with the investigation. And the compromise state was arrived to maintain the welfare within the community, among the community. And the complainant is no longer agree.
So now, because if we have to pass any order, then we have to refer the investigation also, so that the investigation before the police can be.
No, Lordship, the judgment which I have referred to, Lordships, is a case where in the initial stage, the fate of the investigation was not known, but the parties have arrived to a compromise state, and it was compromised. Therefore, this honorable court can quash the FIR and complaint. If the complainant is no longer aggrieved, then what interest the court has to go on still with the investigation? And when the compromise state was arrived in the interest of the community, welfare of the community, Lordship.
Now how the police would be directed then under the circumstances, because the case is still under investigation.
Lordship, since on the basis of the complaint, the learned court below has issued the direction.
That is.
So once the complaint is quashed, automatically everything should go. Because the complainant himself They are not agreed.
Yes.
Lordship,
Yes, please.
the difficulty is with section 409. The sentence, if convicted, punishment is life or 10 years and fine. Now, my learned friend has taken the parity of the order passed in criminal petition 39, 2023, that one my lord has passed the other day.
Yeah.
30, that is, if that ratio is to be taken, that is, the punishment is limited extent up to only 6 months, 1,000. And now here, whether tax circumstances seem a bit peculiar, but economic offenses involved. And superior, as far as investigation is concerned, in Niharika cases that the court should not interfere. So if the case is to be taken in a
That part is difficult, is what I'm
Yes,
saying.
yes.
The investigation part. Otherwise, had it been only in the court, and then since the party, the matter involves with the private,
yes,
and since the party wants to withdraw,
this is a
there will be
constitution.
no difficulty. But then since once it has already been directed to the police to investigate the case,
Yes,
and then investigation is, while the process of investigation is still on,
yes,
can the court,
yes.
the
Lordship,
court, the learned CJM has clearly indicated that can't record.
yes,
Lordship, kindly again come to the same judgment, 2018, 3CC, which I have referred to. The last paragraph, Lordship,
Yes,
paragraph 8.
yes.
In that case also, as a result, this appeal succeeds and is allowed, and proceedings arising out of FIR bearing crime number 267 of 2012, lodged with so-and-so police station are hereby quashed. So FIR was quashed because compromise has been arrived. And my learned submission, which my learned friend is trying to rely, is in a situation where there is no compromise, then definitely court will not have the power. But then here is a case where the compromise has already been arrived.
So why you are referring to what Niharika case?
Lordship, page, this is page paragraph 780. Paragraph 80. Now, here the Constitutional Bench of the Apex Court has laid down certain guidelines, Lordship, principles.
80,
Yes, 80.
paragraph 80.
Yes,
Yes, conclusion.
yes.
Hmm.
Then a relevant portion will be plus 3, 5, 6, 7, 8, and 12.
It is only in case where no cognizable offense of any kind is disclosed in a first information. Quashing of a complaint, FIR, should be an exceptional.
Whether in that case also there is a compromise deed. If it is not there, then that context may not be relevant.
Ordinarily, the court are barred from usurping the jurisdiction of the police, since the two organs of the state operate in two specific spheres. And whatnot. The first information report is not an Yeah, when the investigation by the police is in progress, the court should not go into the merit of the allegation in that file. Police must be permitted to complete the investigation.
When the crime committed is heinous crime, in such a situation, yes. But in a case of civil nature, this honorable court has the power to even quash the non-commendable offences also. And as I was referring to the order which was passed by this honorable court on 30th January 2024, that is day before yesterday, there this honorable court has also referred to the recent Supreme Court rulings of 2019, where there is overwhelming and predominantly the civil character, even if the offense is non-compoundable, can be compounded. That citation has also been referred to, and relying on this principle, the order dated 31/2024 has been passed.
Have you anywhere stated that this is a civil, the dispute is of civil nature
That is
in your petition?
with regard to a construction.
Well, have you stated anywhere?
In the pleading, I have not mentioned because
No,
that
no.
was not the issue.
Hmm.
But the complaint itself says that they have not constructed the building.
Hmm.
But building has been constructed, but it is used as classrooms, not the hostels. That was the only communication gap. And the government, it is a government construction. Government has identified the building and made all the payments.
Where have you stated that there is because of the miscommunication or the misunderstanding?
Paragraph 15, Lordship. Page 9, paragraph 15 of the
Yes.
application, that the petitioner speak to state that the misconception on the part of the private respondent complainants occurred because although the project of the girls' hostel was completed as specified in the detailed project report, no interested students turn up to get themselves admitted in the hostel. Thus, it is temporarily used as classroom for government high school, composite school, and the remaining space is utilized for community purposes as and when required. The girls' hostel being non-functional at present, the private respondent was under the misconception and assumed that the said funds were misappropriated by the petitioners. Hence, the said criminal complaint by the private respondent complainant.
Okay. So what we'll do, which for the respondent, private respondent?
The government has no complaint, Lordship.
I'm presenting the private respondents.
Okay.
Here, we have filed a complaint based on the information received and the documents that were, that has come into our possession, Lordship.
Hmm.
So initially, the allegation was about misappropriation of public funds, Lordship.
Hmm.
The amount was sanctioned for construction of girls' hostel.
Right.
To be constructed in a particular area called Kandinu.
Hmm.
But then further investigation, further inquiry was made.
Hmm.
Then they found that we found that the construction was not made in Kandinu, but in another village, the called K station.
But the construction,
Yes,
construction was done.
yes, so
Okay.
we got information that the amount was siphoned. The girls' hostel was not constructed, but that amount was used for construction of a community building called Kandi Public Union
In another place.
in another place.
Okay.
That was why, as a concerned citizen, because the complainants are law-abiding citizens, they have been in fact, they have approached this honorable court also on several occasions with raising several issues of public interest.
Hmm.
So as a concerned citizen, they have lodged a complaint.
Hmm.
But during the pendency of the investigation,
Hmm.
Lordship, my learned friend was pointing out the compromise date that was entered by both the parties.
Hmm.
So the compromise deed was the outcome of the undertaking signed before the 6 villages concerned,
Hmm.
Lordship. If you would kindly go to the page number 103, this is the undertaking signed by both the parties, the alleged the petitioners here, as well as the complainants, Lordship.
Mm.
So this public meeting was called by the leaders of the 6 villages.
Mm.
So Lordship, it's only 2 pages, if you would kindly allow me to read.
Yes.
So this was executed on 19/08/2023.
Yes.
It says that with respect to the contentions tribal girls hostel at Kandinu sanctioned by the Ministry of Tribal Affairs, the Kandi Villages Chairman Forum comprising of 6 villages, viz. Kandinu, Sishunu, Ihunu, Kestation, Ikhanu, and Songsao, under Tsemenu district, convened a meeting on the 19th August 2023 and had a thorough deliberation on the matter, with both the respondent, Mr. John Kat and Mr. Ilialo Apon, and the petitioner, Mr. Joel Naga and Mr. Gualaz Kat, the case of which is filed in the court of the first class judicial magistrate Kohima. The House deliberated at length and concluded on the following: that the respondents has reimbursed the amount which was raised by the community for the construction of the KPU hall, that respondents shall make the building functional from this day to which this resolution is adopted, that on the satisfactory conclusion on matter, all the parties involved in the presence of the Kandi group villages leader has agreed to make the existing KPU building as a full-fledged tribal girls hostel constructed under the Ministry of Tribal Affairs, Government of India. That the above resolutions arrive at is an attempt, though belated, to resolve the issue to the extent possible as per the powers vested in the village council. However, the KVCF understands that the matter being heard in a court of law, it is within the scope of the honorable court to pass judgment for which any individual or entity is bound to accept. And the next page are the signatories of the villages and the parties concerned.
What does it mean? This means that that the respondent has reimbursed the amount. Respondent, who is the respondent here?
Responding as a petitioner in
The
this case.
Present
Lordship.
petitioners.
Yes, Lordship.
Has-
So
Has reimbursed the amount which was raised by community.
this is the Lordship, for construction of community KPU building, that is it's a community hall. Funds were raised from among the community. So that amount, they're talking about that amount has been
Lordship,
reimbursed.
that
That's what they're saying.
is 10 lakhs was raised for construction of the building by the community. That was utilized for construction of the building, that amount. Including that amount, it was utilized. Therefore, the petitioners, the respondents were directed to reimburse that money. So this money will go to the venue.
So the complainants,
And then
Because
the
this was
respondent-
already utilized
and
for the construction of the
and the
building.
respondent petitioner shall also make the building functional from this thing.
Yes, so it is being used as a girls' hostel now.
and the
It's
paragraph,
not disputed that the building is not constructed, it is constructed.
point number 3, Lordship.
Hmm.
So considering these 3 points resolutions undertaken that was signed, the complainant also decided, because at the end of the day, what matters is that the girls' hostel, the money for which the project has been sanctioned, although it's been constructed in another place, Lordship, if the complainant says that are of the view that if this building is utilized for the purpose of the girls' hostel, then they have no grievance, because the only grievance is that the public funds should not be misused, and that people should get their entitlements, Lordship, because this girls' hostel is supposed to serve to be of help to many other people, especially poor people living in the villages who cannot afford girls' hostel. So the complainants are okay if this is since the points are to the satisfaction, so they decided that they are no more aggrieved.
So reimbursed means already reimbursed.
Yes, the public funds that was raised
Hmm.
was already reimbursed.
That was utilized for the construction of the building.
Okay. So what we'll do is, we'll dispose of, but then we need a status report of the investigation of the case. the state kindly, what is the status? Because subsequently, after the learned CJM has directed for investigation carried out.
Lordship.
But in the meantime, subsequently, they have arrived into an amicable settlement. And then, of course, the petition, they have also made a petition submitted before the IO also. And then probably the IO investigation thereafter has
Not proceeded with.
probably not proceeded, or probably since it was started in the month of May only, investigation must also have been completed. So either they must have prepared by now to submit charges or to final report, either of those. So kindly gather information, obtain instruction, and then the status, the present status of the investigation of the case. So with that, what we'll do in the next week, we'll dispose of the status.
Lordship, so far as concerned, the judgment which I have referred to
So,
Lordship
Yes.
is very clear. At any stage of the
That is
investigation,
true,
this
that is
honorable
true,
court
that is
can
true. Let
interfere.
us satisfy one thing now, the moment, because we are going to dispose of next week. But then for the time being, what is the status of the present case? I just wanted to know. No? So,
If you are to go too technical, I think petitioners have difficulty in the case.
yeah,
But
that is why, that is a little
I think we have
difficulty.
to
Little
making for the
difficult
case more
because-
simple. But if
Because hereafter, the court has also indicated by an order, the impugn order. Have impugn, I think. Huh? So by this order, so court itself has just indicated, says that difficulties, court has no power. So that technical difficulties are there. That is why if the IO can file within these 2-3 days, final report or charges, whatever, then it will be easier for this court also. This court also, the technical part, that also will be done away with. No? So
But
kindly
no,
obtain instruction.
yes, yes.
Next date, we'll take up in the next week.
But my submission is, since it is already
Understood,
compromised,
Yes, yes.
the rulings of the apex court is very clear
No,
that
Lordship,
at any
see,
stage of the investigation,
Hmm.
this honorable court can quash.
if the parties must also help the state. If they really want to go all the back the Supreme Court case, this we
have
can
to
go
go
very
by
deep.
law.
We're very deep. In that case, they have no. I don't think they'll get any relief from here. Now it is involved in economic offense. Now one of the petitioner off record. One of the petitioners, the government servant. There are so many things. So anyway, Lordship,
That is
That is not the
right.
issue
That is
here,
right.
no.
That is right. So because if this is, and in the usual course, if it is allowed, then all the cases will be, so there will be no case. Basically.
so
Hmm.
I think not everything should be
So to obtain instruction,
Lordship.
the status report.
Lordship.
No. Because this a little bit complicated in the sense because it involves the community also, some more than villages, no?
That is
And-
why Lordship, the community has called for a meeting
Hmm.
and they have resolved. And they
then-
have taken a
then the
decision.
Part that reimburse means that means you have already siphoned off is submitted.
No,
And then
Lordship,
thereof reimburse, it means reimburse means you have done the.
Lordship, it
offense
is
has
like
already
this.
been committed
It is like this.
and thereafter reimbursed.
Reimbursed, the word reimbursed was used
Hmm.
because Lordship,
Hmm.
6 villages,
Hmm.
they have decided to construct a community building.
Yes.
For the construction of the community building, they have raised 10 lakhs. And in the meantime, the project for construction of the girls' hostel came.
Hmm.
But for construction of the girls' hostel, land has to be purchased. And with this 1 crore, the specification of the building cannot be completed. And only the money will be spent for purchasing the land. Therefore, the 6 villages has taken a decision that, okay, let us construct this with this fund, let us construct this community building. But before this, 10 lakhs has already been raised by the 6 villages for construction of the community hall. And all this were combining fund, the 10 lakhs raised by the community and the sanction money given by the government has constructed the building. But this building was not used for the hostel because nobody came. Therefore, the community have decided to use as a classrooms for the students. That was used. Government is admitted with that fact. That is the reason why after investigation, everything, money has been paid to the contractor for construction. But the only thing is, it was used as classrooms and other purposes, community purposes, not as the girls' hostel. And why it is not used as a girls' hostel? It is little away from the settlement area. Therefore, no hostelers came to occupy. That is the only reason. And the reimbursement of money by the petitioner is these 10 lakhs, which was utilized for the construction of the building. And that money was mobilized by the 6 villages. That confirmation can be made from my learned friend also. That is my instructions from my client.
So criminal breach of trust is according to you.
Because the 6 villages, the community hall has already been constructed with the cost of 10 lakhs. It was just not enough because in the foundation, 10 lakhs has been finished. So the fund which came from the government was utilized for construction of that, for completion of that building. Therefore, there should be no issue on that, Lordship, because government has already inspected and then made the payment also. It's not that the building has not been constructed. Building was constructed, but it was utilized for a different purpose. That is how the complaint has been lodged by the complainant. But that has been compromised. Lordship, for a moment, can we see the paragraph 16 also? I have just read paragraph 15. I would like to read paragraph 16 also. Page 9. This will clarify the entire thing, how construction was made. Paragraph 15, I have read. Paragraph 16. That the petitioner speak to state that the County Village Chairman Forum, hereinafter referred to as the KVCF, comprising of 6 villages under Chimini district, convened a meeting, general meeting on 19/8/2023 with the private respondents, complainants, along with the petitioners, on hearing about the erroneous case that was filed against the petitioners to clarify the misconception and from further aggravating the case that was privileged and filed, and thus prevent further harassment of the petitioners. The private respondents, complainants, on proper clarification, acknowledged the misconception and agreed upon the withdrawal of the pending criminal complaint. Thus, IA, which was numbered as IA number 173 of 2023, was filed before the Court of Judicial Magistrate First Class Kohima by the private respondents, complainants, for withdrawal of the CR number 4 of 2023. However, the prayer of the private respondents, complainants was rejected, stating that the Honorable Court of the Judicial Magistrate First Class has no authority to stop the investigation, and the said IA was disposed of by order dated 28/9/2023.
Okay.
So to reply this, the rulings I have furnished will take
Yeah.
care of all these issues, Lordship.
So we'll just see once the status of the investigation of the case and then dispose of one another in that, Lordship. Okay. Thank you so much. Mr. C.T. Jamir, Lana Senior,
Assisted by I.M. Chin.
assisted by
I.M. Chin.
and counsel for the petitioner. So, I've also heard the state. Next is the state. Okay. Mr. Land Council, Land Government Advocate, correspondent number 1, and Miss.
Corresponding number 2 and 3.
Appearing for respondent number 2 and 3. Stop. After hearing it some length, this court feel that the no, you have filed this affidavit during this court.
In terms
During
of
this
the
Okay.
order passed
Okay,
by
just a
this
minute.
court on
Just
12/12/2023.
The the petitioner, the petitioners and the respondents. The
Yes, it is a joint affidavit.
both the petitioners and the respondents have filed joint affidavit.
Private respondents.
Sorry, private respondents, 2 and 3 have filed joint affidavit.
In terms of the order dated 12/12/2023.
In terms of the
Direction of this honorable court,
direction or there was no direction, I think.
there was direction, 12
There was
12
direction.
2023. Lordship will find from the order sheet. 12/12/2023.
Okay, in terms of the order dated 12/12/2023. Whereby the parties, while reiterating their earlier compromise deeds. What was that compromise deed or what?
Yes.
As expressed that the respondent complainant has no intention to pursue the criminal complaint case number 104/2023 filed before the Court of Judicial Magistrates First Class, Kohima, Nagaland. Stop. However, since the investigation, however, the case is still under investigation as per the direction of the learned CJM. Where is the already? JMFC by which order? Order dated 28/9/2023. This court.
When the first complaint is.
Felt it necessary to see the status of the case under investigation. Stop. Accordingly, the Mr. Angami Lane Government Repeat shall produce the present status of the which was registered and status of the PS case. Where it was registered, just shown me. Or date is so registered, police case registered. Okay, 101. Not 10. Present status of the FIR number 1623 under section 370. Which PS this one?
Seminyo PS.
Okay. Semenyo. Semenyo. PS case number. Which one is PS case number? 50?
Yes, 50.
50, 2023. Arising out of FIR number 10016/2023 under section 378, 379, 409, 415, 420, 120B, 34 IPC. And produce the same on the next date, which is fixed on
I'll make a deliver next Thursday.
next Thursday. Okay,
Let's see.
Thursday.
For admission, item number 4.
Yes.
Your Lordship, my lord. My lord, in this case also, my lord, in view of the compromise that has been entered between the informant, my lord, with the accused person, my lord. So this quashing petition has been filed, my lord, because some of the sections are non-compoundable, my lord. So it cannot be compounded, my lord. So we have approached, my lord. So my lord may kindly come to my lord, the first to the compromise deed, my lord. This is the basis by which, my lord, we have came before lordship, my lord. The whole allegation is regarding recovery of money, my lord. And the money has been recovered, my lord. So once, my lord, and the FIR also indicates, my lord, is a case of civil nature, recovery of money. I will go to all that, my lord. So first, I will take your lordship to the compromise deed at page 35, my lord. The relevant portion, I will just take note of, my lord. My case is a bit similar to the earlier case, my lord.
Okay.
Yes. So
Page
35, my lord.
First, can we see the FIR?
Yes, my lord.
What is the allegation?
Yes, my lord. I will take it direct to the allegation, page 31, my lord.
31.
31, my lord.
Okay.
My lord, the second line, my lord, when we confronted him and demand to return money back.
Second line?
Yes, my lord, the page 31, my lord. The relevant portion I'm telling you, my lord.
Okay.
Yes. 31, the second line, my lord, when we confronted him and demanded to return money back, Hussain Ahmad Khan claimed that he has no fund now. Instead, he assured us that he would sell his property to reimburse our payment. But later on, Hussain Ahmad Khan reneged on his promises, telling us that take whatever actions we deem fit and make it clear that he had no intention of returning our money or handing over of the property. So furthermore, we have unable to reach him as he has stopped responding to our calls. And thereof the last paragraph, lordship may kindly see, we beseech your esteem, earnest attention to this grave matter, and we pleaded your agency to adopt a suitable measure to ensure the administration of justice and recover our earned money, my lord. That is the affair, my lord.
So this
And
was
if my lord
the
may kindly
transaction. What was the transaction? for?
transaction amount, my lord, it is there, my lord. Lordship may kindly say at page 30, my lord, in the first paragraph. They are on agreeing to terms and condition, we made the payment for purchase of the same.
Where are you?
installment.
Where are we?
My lord, page 30, my lord.
Page 30?
Yes, my
Para?
lord. The first paragraph, my lord. Thus, on agreeing to the
Okay.
terms and condition for the purchase of land, we made a payment for purchase of the said property on installment on various occasions, which are as follows. So these are the payment money. Actually, what has happened, my lord? There was 3 cutters of land, my lord. I purchased half and he purchased half, my lord. Later on, my lord, everything was done. So later on, he decided, my lord, that I will not purchase, the better sell my part also. So he asked me that you sell it, because you are the persons who make me enter this agreement with the persons. I don't want now, you sell it. So accordingly, my lord, he give me authority, my lord, that you sell, or either you purchase, because it is adjacent to your land also. Then you will have a big area.
This is basically a civil nature.
It's civil nature, my lord.
Okay.
So my lord, so he asked me, then I tried my best, my lord, to sell his part, because I had already 1.5 kata, my lord. So it's adjacent.
The
So
section is there.
section is there, my lord. Section is
Offense.
under section, my lord, registered under section, my lord, 420, 409, 468, 120B.
There is no element of 468 in the entire FIR, my lord. And 409 criminal, this breach of trust by public servant, my lord, that is, I don't find, my lord, here. So 420 is, my lord, allegation, and 120B, my lord.
420.
Yes, and the difficulty is that 420 is with the order of the court, it can be compounded, my lord. But 409, 468, 120B is non-compoundable. The trial court also cannot be even. It is in the nascent stage, my lord. It's just under the process of investigation. Just filed, my lord, only on the month of this, my lord. This. It is on, my lord, 29/11, my lord. This FIR dated 9/11, my lord. And compromise was entered on 29/11, my lord.
But the case is still under investigation now.
But my lord, at the initial stage, the statement has been recorded, my lord. My friend is appearing for respondent 1 and 2, my lord. He has filed an affidavit also, private respondent, the informant, my lord. So statement was recorded by the police also. That
The
already
statement after statement was recorded after the.
Because the person was arrested, my lord. This accused person was arrested, my lord.
Okay.
So since he was arrested, my lord, he was in custody. His statement.
Accused person was arrested only after recording of the statement of the this one informant.
Yes, my lord. Once, yes, my lord. Once
he has given the statement against accused.
Your lordship,
Yes.
on the last occasion when we appeared, you have advised prosecution to take step to direct the IO to give a progress report. So I think the prosecution is whether have received any status report from the IO.
Is there any order?
On the last,
order, my lord.
Okay, yes. Do we have any this status report of the
Lordship,
case?
I have not written a status report, but I have a verbal conversation with the IO of the case.
Yes.
This case is not as completed as the previous one, Lordship.
Yes, yes.
So according to him, since according to the IO, as per verbal information, since they have arrived at a compromise, he has further nothing to comment. That is instruction. As far as this case is concerned, I'll leave it to the discretion of your lordship.
Okay.
It's a case, my lord, of civil. Yes, yes, my lord.
Your lordship, since though I'm the aggrieved party in this case, I have received the reimbursement which they have taken. So I don't want to
Have you
waste.
filed affidavit?
Yes, my lord.
I don't want to waste the precious time of the court.
Have you stated that you have received the
Yes,
amount?
they have reimbursed the amount. So I pray before this honorable court to use its wisdom and give proper justice.
Where have you stated that you have received?
My affidavit, Your Honor.
Affidavit by.
It is in the, my lord, this amount is condition. My lord, in the compromise, deed condition number 1, my lord.
Just a minute.
In the compromise deed condition number 1, my lord.
Okay. Deed of compromise.
Yes.
Condition number 1.
Yes, my lord. That the first party had
Received
received
the aforesaid entire
entire consideration amount of the
Okay.
second party, which the first party was earlier given to him for purchase of the said land, measuring stone. So it is clear that the second party had cleared the amount received from the first party, and the second party doesn't have any liability to the first party. Therefore, first party doesn't have any grievance against the second party in any manner whatsoever.
Okay, we'll record the fact of the
Yes,
case.
ma'am. Yes,
Okay.
ma'am. Yes, ma'am.
And the rest of this one. So where do we find the?
Yes,
fact
my lord.
that you
Lordship,
have stated in brief? How it?
my lord, may kindly. Regarding the content of the FIR, my lord, I have just mentioned in page 6, my lord. Page 5, it begins, my lord. If lordship may take up this compromise deed, my lord, that is better, my lord. Lordship may kindly come to page 34, my lord. 34, my lord. This is the actual
Just a minute.
scenario, my lord.
Mr.
GL.
Ghana Council for that. How many? Only one
One petitioner, my lord.
petitioner.
Though there is 2 accused, my lord. So against accused number 2, there is no allegation, my lord, and it is mentioned in the compromise also that in the affidavit also they don't have any grievance against that person because
Two.
yes, accused number 2 because he is a known
So-
person to them, my lord.
Okay, the aggrieved party was only one, and so three.
Yes, 2 and 3, my lord. 2 and 3 are the informants, my lord.
And now I've also heard Mr. Ngame, Ghana Council, Ghana
PP lordship.
PP for respondent number 1. And Mr. Ghana Council appearing on behalf of respondent number 2 and 3. Okay. Fair enough.
Page 34, my lord, you kindly see, my lord.
34.
Yes, my lord.
Just a minute, huh?
Yes, my lord.
This is not a joint petition.
No, my lord, it is not a joint petition.
Okay.
They have filed an affidavit subsequently.
Okay,
34 may be seen, my lord. This is the actual background of the case, my lord.
just a minute, huh? Para. Where you write para was, huh? The petitioner filed this. Petition under section 482 of the Code of Criminal Procedure, praying for quashing of FIR and criminal proceeding against a petitioner. FIR. Where do we find the
Ye-
registered number?
My lord, lordship may kindly come to my prayer, my lord, at page, my lord. At page 22, my lord.
Okay. Quashing of the FIR dated 9/11/2023
In GS.
in which has been registered as urban, suburban,
Yes, suburban, my lord. Yes, yes,
suburban PS case number 64/23 under section 420, 409, 468, 120B of the Indian Penal Code, 1860. And the consequential criminal proceedings. So,
my lord,
arising
this
therefrom in-
GR number, this GR number, my lord. It's consequential GR number, my lord.
okay, therefrom in GR number 731 stroke 2023 pending before the court of the Learned Chief Judicial Magistrate, Dimapur, Nagaland. Okay, stop. Now, page
Page
31,
34, my lord.
34,
4, my lord.
the case of the petitioner is that. Which one? Para?
Whereas, my lord, in the year 2019, my lord, this is the background. my lord. Page 34 down, last paragraph, my lord.
Okay. Case of the petitioner is that in the year 2019, the petitioner,
Yes, my lord. The first party, my lord. The first party is, my lord, the informant, my lord, respondent.
informant,
Yes, respondent, my lord.
the respondent number,
Respondent number 2 and 3, 2, my lord.
the respondent number 2 and 3 had approached
The
the
petitioner.
petitioner for purchase of a plot of land at Gauhati. Stop. However, later on, the petitioner
He arranged 3 cutters, my lord. Half.
arranged.
Yeah, it was 3 cutters was arranged, my lord. We find out half I have purchased, half by them, my lord.
And accordingly, the
Yes,
petitioner arranged 3 katas.
Yes, my lord.
Accordingly, arranged 3
Mhm.
katas of land. For what?
For both of them, my lord, because I purchased for my own and for him also I have arranged, my lord. So a second party here to had plot of land measuring 3 kata for their needs and has agreed to sell half of the land. On being satisfied the position, agreed to purchase the land measuring then half 1 kata 10 less he has purchased.
Okay, sorry, not however, the petitioner then arranged 3 katas of land for their need
Yes.
and had agreed to sell half of the land to the respondent.
Yes, my lord.
To the respondents.
Then the page 35 next.
To which the respondent agreed to purchase. Agreed to purchase.
Yes, ma'am. He purchased, my lord.
Or purchased.
Yes, he was purchased, my lord.
Purchase or agreed to purchase.
He was agreed to he purchased thereafter, my lord.
Okay.
And thereafter, my lord, he
To
wants to
which
sell
the-
again, my
The
lord.
respondent purchased the same.
Yes.
Purchase how much?
1 kata 10 lesser, my lord.
Purchase 1 katha
10 lesser, my lord.
10
Lesser.
lesser within bracket 4.01 area bracket close out of the total how much?
Out of 3 kata, 1 kata 10 lesser, half lesser, half of the land is so ice, it was sold to him, my lord.
Okay. Situated at revenue village Hatigaon
Yes, my lord.
under Moja
Beltola.
Beltola
Yes,
in a district of Kamrup
that's right.
within bracket metropolitan bracket close comma Assam along with Assam type house standing there.
Yes.
Okay, then
Then thereafter, my lord, he want to sell his, again, he want to sell his part, my lord.
who?
The informant, my lord. So he authorized me that you kindly sell it
Okay.
because I don't want to purchase.
However,
Yes.
the respondent
Yes.
then wanted to sell
His share.
his share of land.
Yes. To any, it is mentioned, my lord, you may kindly come to second paragraph, my lord. Is in the 6th line. Later on, the first party has given a proposal. It is there, my lord, in the 6th line, my lord. 1, 2, 3, 4, 5, 6th line, my lord. Later on, first party has given a proposal to the second party to either sell his part of land to any Indian or may purchase it by the second party himself, my lord.
Later on, the petitioner had given a proposal.
No, my lord, the informant has given us.
Sorry, the respondent has given a proposal to the petitioner either to sell his part of land to any intending purchaser or may purchase it by
himself.
himself.
Yes, ma'am.
Stop. The petitioner then accepted the proposal and purchased.
No, my lord, he tried to find out some customer for him, my lord, but he
Okay,
could
the
not find
petitioner
out.
then accepted the proposal and
Tried his best to find out intending purchaser,
tried to find out the intending purchaser.
but the same could not be materialized due to saturated market condition.
Okay, however, the same could not be materialized.
And he could not return the money, my lord.
And he also could not return
Return the money
money
to the informant.
money to the respondent.
Respondent, my lord.
Staff. Okay.
This is how this affair was registered, my lord. These are misunderstanding arose due to lapse of time.
Okay, return the money on time.
Yes, my lord.
Okay. So that much is
Yes.
the allegation against her?
Yeah, this is the
accused. Okay.
yes.
And as a result, the respondent
Lost the FIR.
lost. Where is the,
FIR at page 29, Madam.
as a result? The respondent has lost an FIR, an FIR before the officer in charge, Suburban Police Station, Dimapur, Nagaland, against a petitioner, which was registered
Under section 420.
by SBN PS case number 64, which is registered as, registered being SBN PS case number 6423, 64/23, under section 420/409, 468, 120B IPC. Oh, chap. Achha. So, we'll take up after two. There's some program. I forgot. Resume active.
First, what is it that, like, after 1 year, you can remember those. What is the one? What's that? You just go on to the next. Okay. It's a serious case, and then go to see these cases. Spend that time bonding, even on civil things. And not really application to school. So, when you just maintaining protocol, so everybody get it, don't go to it, because they don't get it. Go in see. And that after what is the he has got time, but no one is coming for in discussion. So whoever goes, so you should take him back anything. Whole day you will say and say.
Better than we was. Looks better. I mean, they're also already bonded. But the major is. Regulations. So. And then just to do it. It should be. So. For structure, how can we assign? Yes. So now it is become district commission. So there is a division to Kohima. Five products. Central zone, central division, upper division, lower division. So the government has changed. Is every state division. Not equal. Once the police. So many around 7-8 eggs. So simple one action that is it. So government we are as you take that one, tax one, expense better. There are two combination, one is tax and another is
Lexis or something like that. Comparative part of X better. You want to learn printed. Printed in actually printed actually the printing daily. And I bought the coupon kind of January. How it was passed, when it was printed, and how everything was done, everything transported to Gauhati. And I bought it only 8 days, 8, 9 days. It was already waiting. It was made just fast. This number, everything was done, discussion, notified. Right? When it was printed, how it is, it's common problem. January to go out, they will file also they will section below, it's usually section, before for cutting section. Now it's for straightforward. Here's a opportunity to make the three sections. Did not change it. Only it's possibility. One possibility that is good. Now most students their growth are changing. You can go. There is no difference. Yes, no. Many students they have passed their maybe married 3rd year now. Not 4th level. But if they pass on, they will find that everything is same. There's no difference. And all that means separate position of law actually very well with these new sections. So I will to be all section these new sections. If you begin to be peaceful. Not a subsection, section. Each of them, everything is there, what it is, it just changes space.
supposed to be possible by any particular day. Or
Only the bill of all the states. What to say, the state is going to do something to say like this. Now, what enforcement, particular point of date or month. Is that is there any December goals? I think now we are modeling the all. To the publication and resolution of the. There should be an amendment in the pursuit of so and so. So the person of the year gives lesson for the. So since we. 20 December. 30 December. 25th December. 3. And by January, the book is now without. That's why. 25th December 2023. The is to be also. Who was passed from the. Both are houses. Now it's already becoming. What do we think for any new of commission of this provision has to come by this new thing. And another thing is that conversion, converse. Some things should be for example, like again, section 34 to the back, the moment things in that, it has become I think 3-6 or something. And there are the objections of all the person. Now, please remember section. Whatever for the end. Now it has come for. All the conditions. You unless you are referring to you of it. Will not entertain that. This is all. With the enforcement last 2 weeks. But recently the book is being published. So. Slowly will come. But last 7 years now, they have not been read. But Nagaland has adopted. It's not That's an overbridge.
With the thick with you,
Item number 8 lang na. So, check ko lang One and two. Wala sabi mo din na alam ko yung complete bro. Wala din. Di dali ko na kahit na. Okay, but then okay could be most okay could be.
put it, okay, put it.
Okay, this is not like.
Okay, then.
Yes, where we were. Last paragraph, na? Okay. Those are registered, na? Being 7 PS case number so and so you have written, na? And the case was case is still under investigation.
Yes, it was initially, it was in investigation stage, madam.
Okay, the case is still under investigation. Stop, huh? Para, during the pendency of the investigation, the petitioner is single, two,
Yes,
single,
single one.
the petitioner and the respondent,
Small number 2 and 3. Page
number 2
34.
and 3,
Page 34. ma'am. Is the
page
compromise.
34.
Is the compromise deed one.
Hmm. Mutually settled the case by executing a deed of compromise on 21,
29 November.
29,
November 20.
11, 2023. Where is the relevant portion? Huh?
My lord, near page 36, clause number 1. ma'am.
Hmm.
Returning the entire consideration.
Okay, whereby the the respondents this deed of compromise is witnessed here. Okay. Mhm. The respondent has received the entire consideration amount from the petitioner, which was given to him for purchase of the purchase of the land measuring 1 katha and lesser. And whereby it is contained, huh? Okay, so it is further stated in the deed of settlement that the petitioner, sorry, the respondent, and since the petitioner has cleared the second part. Received from the first part. Contain that the second, the respondent does not have any. Okay.
Doesn't have any liability towards first.
Respondent does not have any liability
Towards
towards
the petitioner.
petitioner. And as such, the respondent have no more grievances against the petitioner in the case. And in return, and it is also agreed that the respondent will withdraw the said FIR being suburban PS case number 6423. Laws before. FIR, laws, FIR register being urban PS case number so and so. And also file petition before the police for withdrawal if required. Anything else?
No, that is what.
Okay. And accordingly, they have submitted this petition
Yes.
before the police. Where?
No, my lord, it was, statement has been made by them before the police.
Okay. Statement submitted before the police that you are withdrawing the case.
Yes.
Withdrawal. Have you annexed that?
There's no
That is not
info
next.
regarding that, but I've been told that when this honorable court directed prosecution
Hmm.
to investigate whether regarding this case, that the police have personally went to this the respondent place to inquire about the
Hmm.
outcome of this case, and the police has recorded that verbally that they also
Okay, and accordingly, the respondent. It was verbally only.
Yes, the IO has personally went to the
Okay.
respondent place
Hmm.
some few days back. And after that, I think we have verbally called up our prosecution to tell him the outcome of that.
He said, since the compromises arrived at,
Hmm.
yes, further no comment to make in the case. That's what
Okay,
he said.
accordingly, the respondent has informed the police. Respondent expressed their willingness to withdraw the said FIR against the petitioner. Anything else then?
On facts, everything is clear.
What is this? Page 38.
Page 30 is, my lord, since he was arrested, my lord, on production, he was granted bail, my lord.
Okay.
Bail order, my lord.
This is nothing to do.
Nothing to do. Well, they have complained and present themselves before the court and court below,
Hmm.
trial court below, and they have vouched that about the compromise, my lord. That is what.
Hmm. Okay. There are. However, since some of the, and it is submitted that although the parties, the complainant and the the petitioner and the respondent has entered into, agreed, has settled the case by executing a deed of compromise. But since some of the offense registered against accused, namely, what are the
468, my lord.
468,
409, 468, and 120.
409, so 409, 468, 120B
Non-compound.
of Indian Penal Code, are non-compoundable case. So magistrate, no,
Magistrate
okay,
cannot do
okay,
it.
didn't approach.
Yes.
Okay. The petitioner filed this
Petition for person.
petition under section 482 of Code of Criminal Procedure, praying for quashing of the FIR and criminal proceeding against the petitioner.
Yes.
The Bar counsel for the petitioner submits that. So where you have stated that it's a civil nature.
My lord, can I kindly come to? My ground, my lord, phase 12, my lord,
Ground number
ground D, my lord.
D.
D, my lord. That for the sake of argument, the allegations made in the said FIR, petrol admitted may disclose a civil dispute between the parties, and the said FIR seems to have been filed by S1 number 2. A civil dispute in nature, my lord.
Submits that.
FIR admitted to
The
disclose.
matter relates to the transaction of the money transaction and payment of a considerable amount of money for land.
Yes.
Payment of money being as a considerable amount for the land of the petitioner by the respondent, which could not be returned on time.
Yes.
The dispute involved in the case is basically a dispute civil in nature.
Yes. And to that effect, my lord, the judgment of Gyan Singh, my lord, has made clear, my lord. However, certain offences which overwhelming and predominantly bear civil flavor, having arisen out of civil, mercantile, commercial, financial partnership, or such kind of transactions, where wrong is basically to the victim and the offender, and victim has settled the dispute between them, irrespective of the fact that such offence has not been made compoundable, the High Court may, within a framework of an inherent, quash the criminal proceeding and complain or FIR if it is satisfied the case on the settlement.
This
That is a
para?
Gyan Singh, my lord. My lord may kindly come to 341 page of the Gyan Singh, my lord, judgment. Three 41.
Yes.
341, the first line, my lord. However, my lord.
Para?
Yes. From page para 58, my lord. This 58, my lord, is 348 start, my lord. The main part is at page 341, my lord.
Okay.
341, however, certain, my lord, certain offences,
Mm.
this paragraph, my lord, which overwhelming and predominantly bear civil flavor, having arising of civil, mercantile, commercial, financial, and transactions, my lord. So these are required, that has to be washed, my lord, if it both the victim has been settled, because this is private in nature, my lord. And this judgment has been relied by recent judgment of our principal bench, my lord.
Okay. Okay, then in support of this is submission. And counsel for the petitioner relied on the decision in Gyan Singh versus State of Punjab and another reported in 2012, then SCC 303. So this is from however.
From however to my lord, my lord, up to my lord, defeated, my lord. The last second line below, from below, my lord, in that paragraph, my lord.
Okay. Defeated. You write that, huh? Type that. So that those are the facts.
Yes,
the case.
yes.
Okay. Then submit the the respondent number 2 and 3 by filing you file an affidavit, huh?
Yes, ma'am.
Where is the
My lord, page 47, my lord, it will be, my lord, Page number, my lord,
Where you
page-
have stated,
page
where you
three.
have stated that you have
page 3, my lord.
settled on page. Hmm.
This, my lord, may kindly come after that, my lord, affair. However, the bona fide mistakes, my lord. In the, from my lord, from the below, in the middle, my lord, just down in the middle.
Hmm.
If lordship come to my lord, however, the bona fide mistake and misunderstanding occurred between them are clarified and settled by deed of compromise entered into between them in presence of the witnesses.
Okay.
This is
With non.
Down below.
And cross connection. Wherein at para 2, para 3 stated that due to the elapse of time, the misunderstanding between
these what they have thereafter, my lord.
thereafter.
Yes, however, the bona fide mistake, my lord.
Okay, stated that under inverted comma, dot under inverted comma. However, the bona fide mistakes and misunderstanding occurred between them were clarified and settled by deed of compromise deed dated 29/11/2023 entered into between them in presence of the witnesses. The land council for the respondent number, respondent. Then submits that the respondents have agreed to withdraw the FIR in suburban PS case number 6423 lodged against the petitioner. As the dispute between them is resolved with a view to leave it resolved and decided with a view to live in peaceful coexistence. Stop. Anything else you have stated?
So in the this is what, my
Hmm?
my lord, in paragraph 5, they have stated this an issue regarding connection, amicable settlement, and my lord, they want to pray before your honor, before lordship to quash the my lord. That is what they have.
And
Paragraph 5.
And prays that since the matter has been amicably settled between the parties by executing a deed of compromise, and as the petitioner has no more grievances against, the respondents have no more grievances against petitioner, the respondents and hence prays for quashing the FIR in suburban PS case number 6423 under section 420-409, 468, 120B of Indian Penal Code and the consequential criminal proceedings arising therefrom in GR number 731/23 pending before the court of the line Chief Judicial Magistrate Dimapur. Stop. Okay. Mr. Game, Lanet PP. You were asked to obtain instruction, Worship. Okay. Submit state. Yeah. As per the order of this court on 19/1/2024, he has obtained instruction from the eye of the case regarding the status of regarding the present status of suburban PS case number 64/2023. And his instruction is no.
Worship, in view of the settlement arrived between the parties, yes, no further comment to make.
Okay. That's in view of the settlement. In view of the settlement of the case between the parties by executing a deed of settlement dated
29/11.
29/11/2023. The IO has no, he has no comment. And leave the case. For the decision of the court.
Yes, the discretion of this honor.
At the discretion of the court. Okay. Okay, these are the fact. Okay, then rest I'll look at in.
Your Honor, I just want to clarify one though, since the new book has been published.
Not yet signed. Not yet.
It will continue with the whole.
Yeah, it will continue the old, unless it is. So this.
Malad, then Malad is going to quash the affair and the consequential GR case now.
The FIR and the
Yes,
consequential GR
GR
case.
case.
So, so charge sheet not yet filed. The investigation also not yet completed, and probably after filing of the case, investigation, whether he is continued with the investigation or investigation stopped thereafter.
There's no further development.
No further development.
Malad,
Your Lordship.
And submit that and submit that after filing of the present quashing petition, there is no further development in the investigation of the case. Okay. Yes. No. What more?
Since the IO has personally visited the respondents and the IO has inquired regarding the case, directed by this honorable High Court. I think he has conveyed the message that there is no comment on his part regarding the case, our learned prosecution. So I think that will suffice.
Yes.
okay. Malad, I'll just place one judgment that has been relied by the argument, Malad. This Malad, Anita Maria Malad.
Okay.
That is regarding Malad that investigation issue, Malad. If it is court has held that Malad, since Malad, in this case the affair was registered on 2/8/12, Malad. On the month of August, the affair was registered, Malad. And it was, Malad, on the month of November, Malad, that settlement has arrived, Malad. So the court held, Malad, what the Supreme Court held, Malad. Supreme Court held, Malad, that we find that the matter is settled by the complainant out of his free will. Thereafter, my lord, in a case like this, where the proceedings are still at initial and nascent stage, the High Court should have exercised its discretion in quashing the proceeding, my lord. And law in this behalf is well settled by the catena of decisions. In this case, my lord, Gyan Singh has also been
Gyan
referred,
Singh.
my lord. And my lord, and in that, I'll just provide the copy, my lord. In that, my lord, there was a this 29.4 one guidelines has been mentioned, my lord. It states, my lord, that other than those criminal cases having overwhelming and predominantly civil character, particularly those arising out of commercial transactions, my lord, or arising out of matrimonial relationship or family dispute, should be quashed, my lord, when the parties have resolved their entire dispute among themselves, my lord. So I am placing, my lord, this judgment, my lord, where, my lord, even the
Highlight that.
yes, I'm highlighting, my lord.
Relevant portion
Yes, my lord.
and submit.
It is there in the head note also, my lord, that when the settlement is arrived between the parties immediately after
Mark the
commission.
paragraph which
Yes,
we want.
yes, my lord. I am marking, my lord. Ultimately, my the accused are the persons who have been seriously affected, my lord. So, my lord, this is the reason for which, my lord, the court held, my lord. Because it's all about the civil. In any case, my lord, in Gyan Singh also, my lord, there is a paragraph, my lord, that if in this my lord, in Gyan Singh also, my lord, there is a paragraph, my lord, 34, my lord. This is related the Devendra's case, my lord,
Yes,
where it has said, my lord, that if lordship may kindly come to this page 327, my lord, of the Gyan Singh judgment, my lord.
327.
Yes, 37, my lord. In Devendra's case, my lord, there is been
337.
page 30, para 34, my lord. Para 34, my lord.
Yes.
Yes, my lord, in Devendra case, while dealing with the questions whether a pure civil dispute can be subject matter of the criminal proceeding under section 420, 467, 468, 469 IPC, the two judges bench of the court observed, my lord, this is important. The High Court ordinarily would exercise its discretion under 482 if the allegations made in the first information report, even if give face value and taken to be correct in entirety, doesn't make out an offense, my lord. Is a case of civil nature, my lord, where money, recovery of money is there, my lord.
This is civil nature, yes.
Yes, my lord. Recovery of money is there, my lord. And my lord, again, my lord, when this is the one case, my lord, there's been relied in Gyan Singh, my lord. There's another case, my lord, at para 45, that has been also been relied, my lord, where the court has set aside the entire affair, my lord, where these offense of, my lord, may kindly see para 45, my lord. Para 45, my lord. So in a very new judgment decided by this court in the month of July, so and so, my lord. This court was again concerned with the question of quashment of an affair alleging offense punishable under section 467, 68, 71, so and so, 420 and 120 BIPC. The High Court refused to quash the criminal case under 482. The question for consideration was that in as much as those offenses except 420 were non-compoundable offense under section 320 of the code, whether it would be possible to quash the affair by the High Court under 482 of the code or by this court under article 136. The bench elaborately considered the decisions of the court so and by invoking 142 the constitution, it held as under. So 13 and 14, my lord. 14 paragraph, in view of them, we quashed and set aside the impugned FIR, my lord, registered in so and so under section so and so is insofar as the appellant is concerned, my lord. So, my lord, if the FIR goes, it quashes the entire affair. So investigation is something, my lord, is subsequent to the FIR, my lord. If your lordship decide that there is no FIR because it has been settled between the parties, my lord, the Gyan Singh has made clear, my lord. So this has been discussed, my lord, in Gyan Singh, my lord, and thereafter the court come to that finding, my lord, that I have shown your lordship at para 61, my lord, at page 343. That lordship was recorded, my lord. That page 341, my lord. After discussing all these things, my lord, the court come to a finding that where there is a civil dispute, my lord, and when involving, my lord, civil, mercantile, commercial, and financial transaction, my lord, then it has held that, my lord, the High Court within the framework of the inherent has to quash this affair, my lord, because ultimately 482 is for, my lord, securing the end of justice, my lord. Otherwise, justice will be defeated, my lord, and the affected persons will be the accused person because, my lord, everything is in stake of him, my lord.
Anything else?
Yes, my lord, this is what I have said, I have submitted.
Okay.
And this,
So-
and para 30 also of that paragraph, my lord, Gyan Sagar Suri case has been mentioned, my lord, Sagar Suri, my lord, and para 30, my lord, in Gyan Singh, my lord. It says, my lord, ultimately the accused is, for the accused, it is a serious matter for the accused, my lord. Ultimately, he is going to affect, my lord. Once the matter has been settled, my lord,
Hmm.
yes, Gyan Sagar Suri, it is in civil and criminal color, my lord, this issue, my lord. So all these things have been discussed, my lord, in this case, my lord. Ultimately, the finding is that, my lord, that if it is a non-compoundable case and if the matter has been settled between the parties, my lord, then, my lord, it is a financial transaction, my lord, and, my lord, then it has to be quashed, my lord. That is what the law is, my lord. So while looking into all this, my lord, recently, my lord, our High Court has passed this judgment, my lord, considering the Gyan Sagar Suri case, my lord. So these two judgment, my lord, I am just handing over, my lord. I am just highlighting, your lordship, which is relevant, my lord. It has discussed your lordship power under
2014, passed by the learned member MSCT, Dimapur, Nagaland staff. By an order dated 2011-2023, para, this court pass an order. The word is on fourth February.
Yes, sure.
Hmm.
2021.
Stated that pass an order that stating that the June award dated 4/2/2021 in MAC in MSC case number 85/2024. Shall stand state subject to the condition of the condition that the applicant appellant should deposit 50% of the award amount before the registry of this court within 1 month from today. 1 month from the date of passing of the said order. In compliance of the said order and direction, the appellant has deposited amount of how much?
Lordship, 7,64,500.
An amount of is
64,500.
500 before this registry. Where is the document depositing? Amount is not mentioned here.
Yes.
Anywhere mentioned?
Your Lordship, by a check we have given. The check number is,
Have a copy.
I have the acknowledgement receipt. I have not filed it before this honorable court.
You should have filed actually by affidavit that you have deposited. Hmm?
Your Honor, since
has to
it is
actually
on
brought-
record, Your Lordship, in the order sheet also that I have deposited. If the respondents have no issue, then I may stand disposal.
Hmm?
Lordship may kindly check the office note.
Office note only says 50% deposited, amount not mentioned, huh? That will do.
Lordship,
Okay.
that will do.
Hmm.
That shouldn't be an issue.
The amount of, you have a figure number? How
Yes,
much you said?
in,
721?
7,64,500.
64,500 before this registry. Okay, the office note dated 30/1/24 reflected that the appellant has deposited a 50% of the awarded amount in make appeal. In main case, make appeal 9. Main case, make appeal 9.
Yes, Your Honor.
9. 2021 and make appeal 10, 2021. Then also,
In then, there's, yes, Your Honor.
then also deposited.
Yes, but
There are two cases.
there are two cases. On the same
Okay,
judgment.
9, huh?
Yes.
Okay,
Well, we can,
on the same day,
on the same date, by a common judgment,
or common order.
common order.
Okay.
But in this
Who-
one
who's-
relates
who's-
to.
We'll say a 9, huh? Make appeal 9, 2021. Stop. Huh? In view of the above, comma, the operation of the impugn ever dated 4/2/2021 shall stand state. Till the state, till further order,
Till the disposal of
Till the
the.
disposal.
till the disposal of this make appeal.
Make appeal.
Okay, so the order will be same in both the case.
Yes, Your Worship. But there, on the other one, the amount.
Okay, accordingly, no. Okay, in amount what?
Amount
They are
will be
different.
Yes, amount is
Okay,
different.
just a minute, huh? Mhm. Okay, in view of the above, this IA stands disposed of. No, okay,
Similar order,
and similar order in that, but the amount will be.
amount
In
is
second case, the amount will be
6,99,650.
6,99,650.
50. Yes.
Huh, only the amount will be different. Okay. So. So. In the make appeal, any order,
In the back appeal, Your Honor, if the court may adjourn the matter for some time and.
okay.
Lordship, if the LCR has come.
Okay, in the make appeal, huh?
That's yours.
Okay. Hard, both are same. That will be same. Okay, in view of the order pass in the IA. Number 1 is 37, 1 is 36, huh? The impugn ever dated 4/2/2021. Passed in MSC case number 8415. So there also the number also is different, huh? In first case, what that is one is this is 84. One is 85 or what?
Yes, sir.
Okay, 84, huh? Passed by the land at MSCT, Dimapur, Nagaland. Shall state till the disposal of this make appeal. Stop, huh? Para is requested by at the request of the land council for the parties list this matter
After 4 weeks, sir.
after 4 weeks. Okay. LCR called for, is it?
LCR,
there, I think.
it's there.
LCR already for.
Much obliged, sir.
Okay. So check the case number, huh? 1 is 84, 1 is 84. Huh?
For admission, item number 8.
May it please your lordship,
Yes,
the appellant, the petitioner is an appellant. The applicant has filed the IA number 25.
item, this is 7,
8.
8. 8 is for order only, I think. Not for admission. Item 8 is for order, I think.
Yes.
Yes.
Now, here, as per the direction of this honorable court, Talabana was filed before the registry of this honorable court, but on the result of the record, the service report is yet to be returned.
Okay.
Here, I would like to highlight to this honorable court, the accused, the respondent here in this case, their addresses has been abstract, taken abstract from the investigation report conducted during the year 2004 onward.
So this IA is for what?
IA is actually for continuation of
Condonation of
delay.
delay,
Yes,
okay.
my lord.
Now there is notice period, so let the notice receive.
That's why, my lord, what I would like to enlighten before this honorable court. After the filing of this IA, Talabana has been filed before the registry of
Okay.
the honorable court.
Okay.
But as per the office note indicates that no service report has returned.
Notice issued upon respondent number 1, 2 has returned unserved with a remark on the envelope.
Yes,
Addressee retired, hence could not be located.
yes.
So you have to identify, you have to find out
Yes, my
the.
lord. So I'll come to that point.
Yes, please, sir.
So at the time of the investigation of this particular case, they were government officials. Now they are retired or they are no more in service. So I pray before this honorable court that the CBI may be allowed to take a testy service against this respondents. So that
Who may be allowed?
CBI, I'm representing the CBI and the
Okay.
CBI is the
Okay,
petitioner in this case.
you are for CBI.
Yes,
CBI is the petitioner here.
yes, because there was an appeal, criminal appeal.
Okay,
So-
okay, then we'll say, okay.
Yes,
Mr. Land Standing Counsel for CBI.
yes.
Mr. Your good name, please.
Tendang Wapang.
Yes, Wapang. Bendang Wapang, Land Standing Counsel for CBI. Staff. Who submits that he has taken steps upon the respondent number 1 and 2. 1 and 2.
For all the entire respondent, one.
Oh,
two,
okay.
three.
Okay. Okay, respondents, taking steps upon the respondents. However, the office note dated 15/1/24 reflects that notice issued upon the respondent number 1 and 2 as a return answer with a remark on the envelope that the addressee retired. Hence could not be located. And the return service report with regards to respondent number 3 is still awaited. Stop. In view of the above, the Land Standing Counsel for the CBI prays for allowing him to pose services notice upon the respondent by Dusty.
Dusty
Through
service.
Dusty service. Stop. The same is allowed. Stop. According the applicant shall take press steps upon the respondents by Dusty service within
My lord, 3 weeks,
Within-
because I have
within a week from today. Stop. List this matter after 3 weeks. Okay.
much obliged.
For orders, item numbers 9 to 11.
Who is for the petitioner? No one.
Seems none of them appeared, worship.
Okay, no one appears on behalf of the petitioner when the matter was called for, stop. Mr. Angamila, you are for?
I'm for state respondent in item number 10.
Okay.
Read WPC
Is
criminal.
present on behalf of respondent number
One in,
one.
yes, one in lordship item 10.
Okay. This is in 10, huh? Okay. Item 10, 1, huh? Stop. Huh? So this is actually what? IA. IA is for
It's a union of India. Plus
all or similar method only.
yes, these are connected cases, lordship.
You are not appearing in 9 and 10.
I'm appearing in 10, but not in.
Oh, sorry, 9 and 11.
Oh, 11 is an IA.
Oh, IA in 10.
Yes, yes.
Okay. So he's appearing. This is IA criminal 1. IA criminal 1. This is 6. Okay. Well, so you are not appearing in IA criminal 1. Item 9, nah? Okay, no one appears when the matter was called for. List is matter after. We'll say 4 weeks, nah? Item that is in 9, huh? And in 10 and 11.
Same consultorship, so maybe same order maybe pass.
Okay. So there, then no one appear on behalf of the petitioner. Mr. Angami appear on behalf of respondent number 10. Stop, huh? This is matter after 4 weeks, we said, no? 4 weeks, huh? Okay. Okay.
For hearing, item number 31.
No one appears. Anyone appearing? No. No one appears. On or 31.
Lordship,
You are
31.
in the 31.
Lordship. Lordship here, my learned friend, Mr. Tanchuba, he is not keeping well.
Okay.
So, Lordship, may kindly list about after 3 weeks, Lordship.
Okay.
I was informed by the
Okay. Mr. Oseko for the land counsel for the appellant is present. However, no one appears on behalf of the respondent.
3 weeks, Lordship.
This is matter after
3 weeks, Lordship.
3 weeks. Okay.
Bless my Lord.
Anything else? We have one more item. Oh, admission, one item, one more item. Item 43. Okay.
Lordship, here also my senior, Mr. P.B. Paul, was here this morning, but due to some urgent work, he had to go down back to Dimapur.
Okay.
So Lordship may be gracious enough to let the matter come up on 13th of February.
Okay. Mr. Poseko for the land counsel for the petitioner. And
I'm for state.
okay, Mr. Angami for the state respondent.
Manek Konyak on behalf of Mr. M. Solo.
Lana PP, huh? And Manek Konya for respondent number
Respondent number 3, man.
3. Stop, huh? At the request of land counsel for the petitioner, list is matter
On 13th of February.
13. 2. Okay.
Lordship is an interim. Can you continue?
Okay. The interim order passed earlier shall continue till the next date. Huh?
Highly obliged, Lordship.
So,
So we give up to listen to public forum,